meeting back to order. Continuation of the November 5th public hearing meeting. Mr. Chairman, do you have copies of the first one? I do.
This is complete total proof. That's what it is. This is the first one.
If you don't mind, I'm going to allow the board a few moments to read the correspondence before we begin. Does the board have enough time to review the documents?
Yes.
All right, I just must congratulate both attorneys. You sufficiently killed enough trees to help out the planning process. The chair recommends Attorney Turner.
Thank you very much, Mr. Chairman. I appreciate the opportunity to come back. I realize that this is the second night of hearing, and as you just mentioned, there's been a lot of paper in this matter. I do think that just a few things that I'd like to walk through to potentially help orient the board to this matter. I think one of the things that I sensed coming out of the last meeting that there wasn't a lot of hygiene and how we talked about the various parts of this property and the activities on the property. So in my October 28th letter that I sent after the last meeting, on page 2, I included a photograph of the entire 16 East Street property. And in that, I emphasized that over or approximately 11 acres of the property is engaged in haying activity. And in my letter, I noted the Town of Easton versus Clancy decision, in which one of the tenets of that case, one of the holdings of that case, is that the Dover Amendment can apply to parcels greater than 5 acres in size, where the primary purpose of the land is agricultural. And so these visualizations of the property and the extensive amount of the property that is engaged in the haying activity certainly supports that the primary use of this property is agricultural. Now, I note in our letters that Winehouse does not sell the hay commercially. They allow Barstow's Longview Farm to come in and cut the hay and bring it back to their property for promotion of their livestock. And so it is, from my perspective, unquestionable that that land is being used in agriculture, even though there's not a dollar value or a monetary transaction for the ability to take that hay. As I mentioned in one of our letters, it's really a good neighbor thing to do. It is also beneficial for both sides. At one of Barstow's farm stands, they feature Winehouse wine products there. So there is, some cooperation on both sides, but it's not strictly economical. The other thing that I wanted to orient the board to on page 3, I think is the better image, is just the layout of the operation for Winehouse. And that is, we've had a lot of discussion about, the 2010 special permit, what it applies to, and what can be permitted. And what I think is important to focus the board's attention on is that from that image on page 3, this special permit from 2010, which is expressly referenced in the building commissioner's May 31, 2025 letter, is a concern about, and that special permit pertained to the accessory building that was a garage that is now the tasting room. And we've had discussions about the language in that 2010 special permit that had a prohibition on business service in industry. And there are many comments in opposition to our stance that the Winehouse operation is engaged in manufacturing, that the production of wines is manufacturing, and that is barred by the 2010 special permit. But I call your attention to the layout of the property on page 3, because as you can see, the production room, the facilities where, to the extent that activity could be described as manufacturing and through that be described as industry, that is taking place in a different portion of the property. That's taking place in the production room. That being said, I think that it is important to note that, yes, agricultural products, raw agricultural products, can be made into more finished products, and perhaps we could describe that as manufacturing, but it doesn't change the nature of those products as agricultural products. And I think the cases that we cited support that considerably. In addition, I know that Mr. Attorney McLaughlin has referenced the Harvard Brewing case a number of times. We tried to draw a distinction with it in our papers, but I think one way that I would go further is observing that the Winehouse operation does have a farm winery license, which is going to make it different and distinct from the commercial brewing operation noted in the Harvard Brewing case. And I believe that our October 7th letter as Exhibit 7 is a copy of that farmer winery license. And that farmer winery license is issued pursuant to statute, Mass General Laws, Chapter 138, Section 19B. And that statute is very direct, that the purpose of the state acknowledging that there is something as a farmer winery license is noting, the statute says directly that it is granting or creating this for the purpose of encouraging the development of domestic vineyards. Furthermore, in subsection F of the statute, it notes that a wine grower may import the unfermented juice of fruits as part of its winemaking operation. And as we asserted in our communications, that is part of what Winehouse does. It is cultivating grapes on the property, and it is also receiving unfermented, it's receiving grapes and turning that into wine, which is recognized under General Laws, Chapter 138, Section 19B, as part of what a farmer winery can do under its farmer winery license. And lastly, I think, just in terms of the hygiene and how we discuss this property, and I've drawn comments that assertions of it being referred to as a nightclub are just going too far. In terms of what the board has in terms of a concept of what is taking place here, and I'll turn to the gross annual sales on page 9 of our October 28th letter, and that is, to the extent there's any concern or a feeling among the members about, what is going on here? Is it a bar? Is it a nightclub? Are they, selling table service of specialty bottles of exotic liquor or the like? What is being sold there is wine. Overwhelmingly, it is wine. Roughly 85%, slightly 84, 2024, slightly, I think 86% in 2024, 84 and change percent in 2025. It is the sale of wine. And it is not just an open service bar with lots of other liquor being offered. We break out the sale of beer, either beer brewed by Winehouse itself or beer brewed by Drunken Rabbit. And we provide the other revenue figures, paltry, under 5% of all other things. 85% of all the economic activity here is from the wine produced and/or produced and grown at the facility pursuant to that farm winery license. And so, yes, there are promotions, there are innovative things that the Winehouse staff comes up with to draw folks to the venue, but the commercial activity, the revenue generating activity, is the sale of wine at the tasting room. There are not tickets or admissions sold for the music concerts and the like. The economic activity that Winehouse is engaged in is in the sale of the wine that it produces. And with that, I think it's very strong for the board to be able to find that this is predominantly an agricultural use. The primary use of the property is agriculture, that the tasting room is effectively the farm stand for that business. I know, just as I sat down, Attorney McLaughlin provided me some documentation showing tax records describing this venue as a restaurant. I don't think that's of any moment in the Modern Continental case that we cited to you. That farm stand operation also had a food sales restaurant component. I don't think that that is incompatible with the notion of the tasting room being the farm stand for this agricultural activity and the point of sale for those products. I think it's very much in keeping with the cases that we cited to you where Dover Amendment protections has been found repeatedly for this type of commercial activity. By statute and by case law, the Commonwealth has frequently and regularly found that agricultural activity is commercial activity. folks labor, making wine, growing grapes, that end product is going to get sold. This tasting room is just in that chain, providing an opportunity for the fruits of that labor and the fruits of the land to be sold. And I think the ZBA can be very comfortable in finding that this activity is protected by Dover, and therefore can proceed and doesn't require other zoning relief. Thank you.
For some clarification.
Yes.
If you might. Are you, could you tell me if there's any production of wine or other products in the tasting room at all?
No, I don't know, not to my knowledge, I don't believe so.
And when you have these events at the tasting room, is it all just confined to inside the building or is it outside the building as well?
No, it is not. In nicer weather, it can be outside the building. That image on page 3 of our October 28th letter shows a patio space outside of, between the tasting room and the production areas. And outlined in green is what is designated as a serving area, and that pursuant to its licenses is where Winehouse can have customers enjoying their wine products. So the serving area is larger than the tasting room itself. And Mr. Chair, thank you. Your question has reminded me. The primary reason for today's letter was a vehicle for getting before the board the entertainment and common victualers licenses that were granted to Granby. I apologize, I didn't have those in hand when I made my last submission. But one of the reasons why I think those are important to share with all of you is a discussion that we had before, in that in large measure, the entertainment activity is governed by the entertainment license issued by the select board, and that to give this board comfort in knowing that, yes, there is a regulatory regime whereby Winehouse gets permission from the town to conduct such activities. I don't know if that's more than you needed, Mr. Chair, but serving is not restricted to the tasting room. There are some outside spaces that are involved.
Thank you for that clarification. Another question I have is, other than the hang, and thank you for clarifying that there's no revenue generated by the hang, are there revenues generated from other produce grown or produced on the property?
Yes, insofar as in the percentage of gross annual sales, some of the agricultural products go into the beer that is sold, and some of the other elements may be used in the creation of the products, but and if so, they're captured in that last, the last category is other non-products, non-farm products. I don't know that those other that the other agricultural products have advanced so much to be revenue generating, but not in any material way.
So let me first state that there's been a lot of idioms and proverbs mentioned in the last meeting, and I'm going to probably use a few myself this evening. I would like to come to the elephant in the room. That's idiom number one. The question I have is simply this. You are referring to qualification of protection of the Dover Act.
Yes.
The fundamental question I have is this, is that when you were issued the cease and desist order back in 2024, why didn't the applicant appeal that decision to settle that question at that point?
To the best of my knowledge and awareness, I think you can read that letter, and the letter says, in addition to stating that there's a cease and desist, it also says, why did you come talk to me? I think, in effect, at the end of the letter. And my understanding is that there were conversations that were had, and there were also disagreements with respect to the provenance of the building inspector's authority in that regard, in part because of the protection of Dover. There were other personal reasons, personal health reasons that interfered with the ability to pursue that at the time. Beyond that, I wasn't engaged until November of last year, so I was not intimately aware with how the matter proceeded with the issuance of the building commissioner's letter in May of 2024.
I'm sure you can appreciate the position that puts the Board of Appeals in terms of considering whether or not this is protected under Dover.
Well, part of the reason that the matter is framed in this way, I think, is that in the prior history of this matter, this board did not have an opportunity to assess all this information and get to a determination. And so we felt that it was important to have the board get that opportunity and to issue an assessment based on its review of the information to make that determination.
Thank you. The other concern I had is in your documentation here, you're referring to the tasting room akin to a farm stand.
Yes.
And I'd like you to further explain that, because at first glance, and reference to not only the information regarding the Board of Assessors assessment analysis, but also the building permit application that was subsequently applied for a change of use. The change of use application was for specifically the storage building to change it from use as storage to use A2, which is assembly. Your farm stand, it would seem to me, as a former building official, that use group would have been changed to a B. So could you kindly explain your rationale and the reasoning why you're still maintaining the likeness to a farm stand rather to other uses that use group A2 would be?
Well, I think that, again, in our October 28th letter, in particular, the Town of Natick versus Modern Continental Construction, there's a very clear sense in that case that the types of activity associated with such a farm stand is protected by Dover. And I see the point of sale in the tasting room as as you say, very akin to the kind of point of sale you would have buying agricultural products from a farm. With respect to how the change of use form should have designated that, I understand your concern. I think that given the protection that the use in the building should have, I think that's the overriding concern. If there is a concern with respect to that use designation, we could return to assess that. But I think that from my perspective, the overriding importance in terms of the zoning protection that the use and activity should have as being protected under Dover is the more overriding concern.
All right, thank you. Does any member have questions, Mr. Chairman, at this point?
I just want to make note that I guess that on the town card here, where it says notes, it says winery. And it's charged for the land as a winery. And then I have a question as to your statement about, I know you weren't engaged, the attorney, but I read the letter and it was conflicting whether it was like an absolute cease and desist from, hey, we got problems here, let's talk about it. But I'm not an attorney, but from what I understand, before you can challenge something in court, you have to go through all of your administrative
Remedies.
first. You know, I forget the fancy name of it, you have to go through your administrative, so if this goes, then that's when you go to court. Because sometimes you go to court first, they throw it out and say, did you go through all your administrative options? I know that being a licensing board, you have to do that first, so
That was precisely my question when I was brought up earlier.
yeah, so I just want to, well, that's, I don't know, I believe I'm correct, that's why it probably wouldn't have been challenged in court right away, because you have to go through all the administrative stuff. But anyway,
Go ahead.
You said the patio's licensed under the tasting room?
Yes, it's part of the area where alcohol can be served, correct?
And that's under the tasting room license?
But it's under Winehouse's license, yes.
Because I believe there was a stipulation in the license originally about serving outside. Is that not correct?
I'm not sure I understand the question.
You said it was licensed, so I was questioning the ability to serve alcohol outside on the patio.
Pursuant to the pouring licenses that the facility enjoys, customers can take those beverages. It's more the concern of where beverages can be consumed. And so the business has to designate those areas for the purposes of those licenses. And so that is what's designated.
But not outlined in the permit.
Sorry, say again?
It's not outlined in the permit,
In which permit?
the one you're referring to that you gave us a copy of.
Oh, in the entertainment license?
First one's entertainment, the second one,
The common victuals license?
these were the permits withheld by the select board with conditions, stipulations?
Yes.
Okay, what were those stipulations?
For the property to have a certificate of inspection from the building commissioner.
And the fire department?
Yes. And those were received.
Your question answered?
No, I'm good.
Maybe? Okay. Do you have any questions?
Yeah, I just, if I'm hearing everything right, it sounds like basically they were issued a cease and desist and just didn't pay any attention to it. And that, number one, is the wrong thing. Number two, and this is only from my personal knowledge, why isn't the property in chapter? If it's agricultural, which there aren't too many agricultures that are not in chapter, why isn't it in chapter?
I'm not privy to that particular reason or circumstance. I think being in chapter is certainly a strong indicator of the agricultural nature of the property, but I don't think it would exclude a finding that the primary purpose is
And
agricultural.
Are you considering Jameson Farm and the White House a farm business?
I would describe it that way.
So farm business is defined in the general bylaws that 50% of which products come from the farm have to be produced on site. If you're considering it a farm business, are you saying that 50% of the products being renovated is being grown on site and used?
I'm not looking at the statute necessarily, but
It's
again,
it's
pursuant.
part of the definitions of the zoning
The
bylaws.
zoning bylaws is telling Granby.
Okay.
I have a copy if you like it.
So again, I think as we've described pursuant to the farmer winery license, it does allow for the bringing on of agricultural products for the production of the wine. And pursuant to 48 Section 3, the language describing the farm activity is that the materials are produced on site. And we would maintain very strongly that the wine, the end product that Winehouse is producing from agricultural products is produced on site.
Just as a clarification on that point, section 3 doesn't refer to 25% of the product being produced has to be grown on site.
It doesn't say grown, it says produced.
Mr. the town voted some years ago to be a ag-friendly community. Has the zoning bylaws been updated since that to reflect what the Mass General Law has to say underneath that section that we accepted? What I'm saying is the zoning law bylaws, I don't know about an attorney, but it's possible the zoning laws could be in conflict with what the town voted for.
I don't know the answer to that question. I know exactly what you're referring to.
Yeah.
The town meeting did that. They
So,
may have-
it's just, I'm just asking, I don't know. I don't know the answer.
Mr. Chair, I have one more question, please. How many pounds of grapes and how many pounds of hops are generated?
I don't have the figures in terms of pounds that are generated. The best measure that I could point you to would be the gross annual sales that we disclosed in our October 28th letter. And I don't offhand have necessarily a direct correlation to what that means in terms of pounds or gallons necessarily.
Because there's a chemistry that goes into doing wine and doing beer that goes to how many pounds of hops are required to make a certain type of beer.
Certainly.
So if that's not present here, you can grow 100 acres of hops and 100 acres of grapes, but unless it's broken down, what is that being used for? Other than being used for wine and beer.
Mhm.
But if you want to have the percentages with the weights, that's a moot point.
I'm not certain that I agree, just insofar as the analysis for the zoning discussion that we're having in terms of whether or not the property qualifies for protection under the Dover Amendment, the focus is either on the total acreage that is under cultivation or the revenue generated from those products. I don't recall, I'm not familiar with necessarily a threshold weight or gallonage measure that would be required. I think, in general, I think I agree with you, and I think your analysis is sound insofar as, yes, some measure of hops go into a product, but I think that the cases that we cited, in particular Modern Continental, they state that they are less concerned about finding what percentage of an end product contains what percentage of agricultural products that were grown. So for example, I think they talk about fruit pies and other things that might wind up in the farm stand, so long as some measure of it came from cherries grown on the orchard or for the purposes of beer, some measure of the hops went into the product. They are very comfortable finding those to be agricultural end products that can be then counted in terms of revenue. So that's the analysis that we've been bringing to it.
Any other questions at this time? Just for the record here, the definitions under our bylaws define farm business as a business established for the purpose of sale of farm products, 50% of which must be raised or produced on the premises or elsewhere in the town of Granby.
Okay.
We'll come back to that when we.
Well, I appreciate that clarification. Again, although I think that is an interesting thing to explore, I don't think it would prohibit the board from finding that the Dover Amendment necessarily applies. Whether or not the business could qualify as a farm business under the bylaw, I think is a question different from whether, for zoning purposes, if it's entitled to that relief.
One last question at this point. In your original letter, you mentioned that, I think it's the second letter that you wrote to the board, that the focus of the tasting room is the focus, not the whole parcel of land for qualifying for the Dover Amendment. Is that my correct understanding of your letter? Do you recall?
I don't recall that specifically. I would say that the two are intertwined insofar as the tasting room is part of the agricultural use of the property. Again, more akin to a farm stand. It's a continuation of the agricultural activity. It's not separate and distinct from the agricultural activity. Thanks.
We'd like to have you back.
That's fine.
on the hot seat, I mean, the podium, later.
That's fine.
Thank you. Mr. McLaughlin, Chair recognizes.
Thank you, Mr. Chairman. If I could try to, Attorney John McLaughlin, representing Morsetts. If I could try to address a couple of issues. One thing is this talk about common victicular licenses and alcohol beverage licenses, as if that somehow deals with the zoning in any way whatsoever. It doesn't. I don't know if I said this before, I was able to get a liquor license, a golf course liquor license for the very first time for a disc golf course instead of a hit the ball with the stick. And that was one thing we had to deal with, but separate, just because I got that didn't mean I was okay for zoning. I still had to deal with the special permit, which went to appeal to the Superior Court. They're separate and distinct. Just because you get a common victicular license, or just because you get a winery license or a brewery license doesn't deal with zoning. Those licenses necessarily infer that you're going to use them in a district where you can use them. It doesn't mean that if you get a brewery license and you put it into a residential home property district, that it's fine because you got the liquor license. So that's a red herring. The fact that he shows, I've got this license, I've got this license, I've got this license, has nothing to do with zoning. Those licenses infer that they're going to be used where you can use them, okay? Why Brother Counsel is saying that he can get around that because of the Dover Amendment, okay? Now, a couple things about the Dover Amendment. Number one, I think everybody's correct. He had a clear, my reading of the 2024 order was quite clear. It was saying you can't do your restaurant, bar, nightclub facility in this residential district. And he never appealed that. I understand he didn't have an attorney at that time. That's unfortunate, but he never appealed it. So you can readily say, what are we doing here? This is still a valid order. It was never appealed. And you just can't do anything on the entire property, not just the tasting building. That's over. Also, it sounds picayune, but I pointed out that this particular amendment was too late. He was supposed to, within 30 days, get something to the town clerk. Instead, he gave it to different boards and not the town clerk. That's fatal, too. I mean, it might sound picayune, and I know your town clerk was on vacation, but, that was a problem. So why are we here both times say you can't use the tasting room, you didn't appeal it on time, and you can't use that property for this facility, you didn't appeal that on time? That would be a quick and easy one, but we don't have to go that way. But both those things are really, really hanging over the head of the board. That we shouldn't even be here, he's too late, he's too late, he's too late. Getting to the Dover Amendment. Okay, the Dover Amendment, before you start getting into the percentages of where did this come from, where did this grapes come from, where did this yeast and hops and barley come from, before you even get to that, the Dover Amendment only applies if the property is primarily commercial agriculture. Okay? It has to be primarily commercial agriculture before you can even start getting into the numbers and the calculations and the analysis under the Dover Amendment. And here, the issue is this really a farm that's doing something to help its life as a farm? Or is this a big bar facility that happens to be growing some crops that they hay once a year? That's what it is. And the way to do that is you look at the net effect. You can look at a variety of things on that property. I say the main thing to look at, because I'm a little bit of a capitalist in my mind, is you look at the money. You look at the money. It's like, what is making the most money? Is it the bar, brewery, winery, outdoor entertainment? Is that making the most money? Or is it the farming? It has to be the farming to come under the protection of the Dover Amendment. The little thing you're doing to help your farm can't be much bigger than the farm. Then it just is backwards. So you can look at a variety of things. Aside from money, you could look at the number of buildings. When you look at the buildings, it looks like most of the buildings are being used not for pure agricultural enterprise, but for this entertainment, alcoholic beverage facility. You can look at the number of employees. He could have told us, oh, no, almost all my employees are out there in the farm. No, I don't think that's the case. I think almost all of his employees are selling booze, not farming. And the third thing you could look at is the acreage. And admittedly, that's the only one, okay? Just the acreage, if it was just the acreage, apparently more acres are being hayed than take up the massive entertainment complex. But I cited to you, there's a Richardson case where a farmer was doing earth removal, what they do frequently, they do that. In this case, the farmer was making much, much, much more money off the earth removal than he was from his farm. And went to the land court, and the land court said, well, he's using more land for the farm than this seven-digit business earth removal, so we gotta give it to him. The appellate court said, no, that's crazy. You look at the whole thing, and you do look at the money. And when you look at the money, when you look at the number of employees, when you look at the number of buildings, any way you look at this is an entertainment facility primarily. And one of my client's neighbors has brought a tax record, which I just got, that show that even your tax assessor is saying that building's a restaurant now, not a farm, not some kind of farm stand, not farm. Your own tax assessor, that's not definitive. Your attorney will tell you that's not definitive, but it's a piece of evidence that helps what I'm saying. So we don't even get to the Dover Amendment. We don't, because this is not primarily a commercial agriculture property. So you can't ask for the protection of a farm when you're not really a farm. You're primarily an entertainment alcohol business, and the farm is much, much less. So I don't see any way around that. What we wanted, what we hoped to see, what a few of you asked at the last meeting was numbers, dollar figures. How much money do you make from your bar, and how much do you make from your farm? That would be something that would be helpful for your analysis. They did not give it to us. 24 pages, plus an additional few pages today, with still no numbers. They didn't give us the numbers because I'm sure they're terrible. I infer they're terrible. I mean, how much money do you make from all of your farming compared to how much money do you make from your business that's supposedly quote unquote in support of the farming? It's off the charts. So I don't see how we get to the Dover Amendment. If we did, then I want to stress a couple things. He says that the tasting room is there to support our winery. The winery is not growing anything. I mean, I've given you the Harvard case that says that taking, hops and yeast and barley and making it into a beer is a form of manufacturing. The same would hold true with a winery. What is the growing when they say produce, as we talked about your farm business? The same holds true with this amendment. It's manufacturing is manufacturing, and growing and raising is something else. And so he's saying, look at most of the stuff that we sell, we made here. Well, isn't that nice? What if you had a clothing store and you made all the clothes in your farm? Is that okay? No. What matters is what do you actually grow in the ground on your piece of land, or what animals do you raise on your piece of land? I did another case where people brought in food trucks. My farmer did. My client brought in food trucks. I had to show that 25% of the food in the food trucks came from animals that were slaughtered on my guy's property. Here, he's got food trucks. How much of the food was grown or raised? We don't know. He's got a winery. How much was raised from his grapes? It never even gets to 25%, and it has to be at a minimum 25%. And I believe someone showed me tonight the menus of the wine. Most of it is not from his grapes. So I don't know, how these numbers are working, and we don't have the cash numbers, which we should get. In fact, because you asked a specific question that they have not answered, some boards would say, okay, you're done. If you're not going to answer a question that we ask and you don't answer, and it's a relevant question to the matters before the board, that in and of itself could be enough to say goodbye, it's over. I think that and when it comes to the room itself, if you get there, you shouldn't even have to get to the room, but if you look at the charts that he put in with for the construction, for the materials on the reconstruction of the building, they say part of it is storage. That's storage for manufactured goods. That's storage for the wine that they're making. And the tasting room is intricately related to the manufacturing. It's not related to the farm. You know, you gotta understand that making stuff that is grown on the property is different than growing stuff on the property. They're conflating the two as if they're one and the same, and they're not. Admittedly, if you had, I cited to a case in my brief where there was an ice cream stand, and for a farmer, but most of the ice cream was coming from Connecticut. Most of the milk was coming from Connecticut, and they said you can't do that, you know. And they said you can come back here someday when you have most of your milk is going into your ice cream, but until then you can't do that. But understand, in that case, it was clearly still a farm. Here, it would, you know, here would be like you have the huge, massive ice cream stand with a tiny, tiny farm. You know, so we don't even get to the analysis of how much percentage of his grapes are in the wine. If we do, he doesn't have the minimum. 25% of what he's selling for wine has to be from grapes that are grown on his ground. 25%. I don't see that number right now. Also, the beer. If he's selling beer, it should be that 25% of the hops and yeast and barley are grown there. In the food, like I said, I've seen cases where towns have told me to have my food trucks that show that the food comes from my farmer's land. None of them fit. So none of these things fit. He should have appealed the 2024 order. What did he do? He ignored the 24. That's what happened. You know, he probably knew that the town select board wasn't about to pay Attorney Costa to go to land court, Superior Court. It's very expensive. And he said, I'll just keep doing what I want to do. If they're not going to pay Attorney Costa to come after me, just keep doing it, which is wrong, and you shouldn't support that. That's what happened. I just don't see how the Dover Amendment applies at all, because this is not primarily commercial agriculture. Once you get into the analysis, it doesn't work at all. There's no 25% of each of all the things he's selling has to be grown there. That doesn't happen. And you cannot equate manufacturing on a farm property as farming, because it simply isn't. I just don't see any way that this is justified. You would be fully within your rights as a reasonable board to deny this application, and even to say that the whole property should not be operated as he's been doing. I just don't see any way around that. Thank you. Do you have any questions?
Beginning with the first part of your statements here regarding not showing actual revenue numbers, reading the statute, section 340A, it talks about percent of either volume or gross volume or volume, gross dollars and volume. Ultimately, as I read the statute, the measurement is percent of whatever it is. So, in my view, the fact that they didn't produce dollar numbers, I think, is irrelevant. That's my personal opinion, only because you can establish what the percentage based on the chart that was given to us by the applicant. I would like to go further on the question of produce. Mr. Durning pointed out that it does say produced by the owner of lessee of land for which the facility is located. So can you please expand upon grown versus produced?
Yes.
Not the same, or they?
No, I mean, first off, we're talking about a farm, okay? We're talking about a farm. So when it's produced on the farm, they don't mean manufacturing. They mean produced. That term means it's either grown on the farm or it's an animal that's raised on the farm. If there's a case that says otherwise, Brother Counsel should show us that, because we're talking about a farm. When you say something's produced on a farm, you're not talking about a factory that happens to be set up on the farm, or a brewery or a winery. You're talking about materials that come from the farm. producing something on a farm is either growing it or raising the animals. Also, when you talked about how we get to the numbers, and you're right, the first sentence, by the way, has 312 words. It's a tricky statute. It's a very, very tricky statute. But in the beginning, it says that it only applies to commercial, a property that is primarily a commercial.
Primary purpose.
Yes.
Commercial
So,
agriculture.
yes, that's before you get to the analysis. So what I'm saying is, before you get to these number crunchings like we're doing, before you get there, you have to be on a piece of land that's primarily a farm. It can't be primarily a restaurant and just a little bit of farm. That, in this case, that's what the Richardson case I gave it was about. I mean, that guy had a farm, but he was making much, much more money from his land use as earth and materials business than he was from the farm. So they looked at that and said, oh, well, what are the percentages? No, they didn't even get there. They just said, we're not even going to get to the percentage analysis. We don't have to, because this piece of property is not primarily a farm. It's primarily an earth and materials business. And here, the exact same thing works for this property. This is not primarily a farm. Really? How many employees are out there full-time farming? How many buildings are full-time farming? How much money do they make from farming? None. It's primarily a restaurant. And that means we never even get to the analysis of the numbers, of the percentages, because it doesn't apply. They're just not enabled to use the protections. And there's good protections in 40A, Section 3, but they never get to it because they're not really a commercial farm. It's only a commercial farm that can use this statute to protect itself from the zoning that they would be doing otherwise. But this isn't really a commercial farm.
Thank you.
All right.
I have-
Sure,
I have
yeah,
one
yes,
question
yeah.
for you, Ron.
Yeah, absolutely, Mr. Chair.
I asked Attorney during this question as well, and I hope you could expand upon it. And this is based on the fact that the cease and desist order was issued in '24.
Yep.
And the ramifications of not appealing that order at that one time. In your view, what are the ramifications if this court reconsiders that question, whether or not this is actually protection under the Dover Amendment?
I think the board could do this. I think the board could say that they're doing an analysis about the appeal that's before them and find that he doesn't fit the protections of 40A Section 3. And you could say, that in addition, we find that there's an outstanding order that was never appealed that says exactly that. And I don't see that any way around that. He simply apparently ignored the order. I mean, I guess, he knew it was going to be expensive for this town to appeal, not to appeal, but to try to enforce the order. The order's out there, and he's just acting as if it's not out there. And you can't do that. That's an affront to this board's dignity. I mean, to the government. It's just saying, I don't care. What it says, I'm going to do what I want to do because you can't afford to go to land court. Nah. Which is very not a good way to do business. And this board should exercise their authority and say that not only do you lose this appeal, but we're finding that the entire business is incorrect.
Mr. Johnson, do you have any questions?
Not at this time.
No.
I'm good, thank you.
All right. Thank you very much.
Thank you, Mr. Chair.
Are there any other speakers who would like to speak? Mr. Domergue? And I would remind you that it has already been discussed, and I would ask you to move on to the next topic.
Right. Rich Domergue from Bachelor Street. I had a few comments on the October 28th letter or memo that the applicant responded to the board in answering your questions. None of your questions were answered, as far as I'm concerned. I'm a retired CPA. I've dealt with IRS on a regular basis. Now, the first comment I would say is that this is the first time I heard the applicant say that he takes his hay and basically gives it to, I think he said Barstow Farm, in exchange for them selling his wine. That's called barter, that's illegal. You have to pay a tax on that. But the point is that, and the IRS would like to know that, but the point is that he's putting a value on that hay at such a low amount, basically he's giving it away. So I would say to you that you should not count any of that acreage in total, because that's one of the methods you use to determine whether they're a farmer or not. So he's giving it away, so it should not count. The second thing I would say is that Mass General Law always supersedes local bylaws, always. So you should always look at the Mass General Law first. You can be more restrictive than state law, but you can't be less than state law. So if you go to, because I know there was a question about that, if you go to Mass General Law, Chapter 40A, Section 3, that's the section, that's the Mass General Law that deals with the 25% that we're talking about all the time. Now, they supplied 24-page document. None of it was what the board requested. This board requested revenue, and I think revenue is important. So you cannot tell, because one bottle of wine sells for $50, the rest of the wine sells for roughly $25. How do you compare that to hay, and how do you compare that to hops? So, and I think the law mentions revenue, if I'm not mistaken.
We'll come back to that.
Okay, and so if you look on page 9 of their chart, they again only show percentages, but this is the one sentence that really struck me. It says, accordingly, Winehouse derives well over 80% of all revenue from the sale of wine produced on the property. Now, that's a lie. They don't produce over 80% on the property. They even tell you up above, wine produced from grapes grown on site, 15.51% in 2024, 17.98% in 2025. Now, assuming those are correct, which you can't tell unless you know what the revenue is, they're telling you that of the wine they produced on site, 15.51% was sold. So right away, they're telling you they produced less than 25%, because if you look at Mass General Law 48, Section 3, it tells you 25% has to be grapes that come from the ground on the area that you're talking about. And they don't have more than 15% that they say. But it can't be verified unless you know what the revenue is. But I just wanted to point out those points.
Okay, let me clarify the statement you made regarding revenue. Section 3 does not specifically say the revenue. It says the percent of the revenue or the volume. So it's not required to have, my view, my reading of it, this does not require mentioning number of dollars, because you can calculate the percentage and give a good indication as to if you're meeting the 25% rule, for example, or not. So in my view, you don't need to put the actual revenue, and I don't think it would be appropriate to do so, quite frankly.
Well, this board asked them for the revenue, number one. Number two,
Yes, I understand.
how do you know those percentages are correct unless you have the revenue?
Well, that'd be committing perjury, wouldn't it?
That's right, it would.
So, I don't have any, personally, I have no doubt that the numbers are not accurate in terms of percentages, and I think that's the key of the problem. Does anyone have any questions of Mr. Domerty?
No, Mr. Chairman, Mr. Domerty made a statement that the state law applies first, and I just moved it over amendment. And the Dover Amendment is the common name for the Massachusetts general law. This law exempts agricultural, religious, and magical use from certain zoning restrictions by limiting what zoning requirements apply to land and structures and all these uses. You know, it goes on and on. But, so it seems like the Dover Amendment is pretty, you know.
Well, it's
He
Mass
just
General law.
said- He just said, right, he just said it trumps the local zoning laws.
Right,
Yeah, so thank you for that.
okay.
Anyway.
Anything else?
Mr. George, you recognize?
Okay. A couple statements was made at the previous hearing concerning the plants and stuff. Mr. Tronky purchased the land in September 2020. There was no grapes being grown on the land in September 2020. If you recall, Mr. Chairman, I gave you copies of bottles that had wine dated 2020 and 2021 on them. That was bottled at the wine house, right on. Mr. Tronky never had a license till 2022. In addition to that, his license, which is the 13B that we talked about, requires him to file yearly with the ABCC on the amount of revenue he's producing. So if you want the revenue, you should be able to get them from your local liquor authority, our guys, or go to ABCC. But also within that, when we look by volume, like you said, we reviewed the wine list on 7 October and backwards, and the wine house has produced 16 different types of wine since 2020. Out of the 16 types of wine, only one came from the wine house grapes. By Massachusetts labeling, you have to state where it comes from. Massachusetts is a 75% requirement, where the state of California, where all the other grapes came from, I should say, the other 15 came from California grapes. If you're going to state the code on them for AVA, that means 85% of those grapes have to be in that bottle. There's your volume right there. So if you figure out the volume based upon that, 93.5% of all the grapes came from California. 6.5% came from the actual wine house itself. And if you want the cost, I don't know what the ABC is going to tell you for the years 2020 and 2021. If he doesn't have a license, I'd be very surprised if he put anything in for revenue in those 2 years. But you have pictures of the bottles that we collected that say 2020 and 2021 on it. And like I say, as the volume goes, 16 types of wine have been manufactured, produced, whatever you want to say, by the wine house. Only one came from the wine house grapes. That means 93.5% came from California. I was just talking volume. That's what you will. You didn't want me to say anything else, so I'm not.
No, if you're finished.
Yeah, that's good.
Thank you. I want to thank you for your comments. However, I also want to bring to the point that the statute says gross dollar sales or volume percent.
Yep.
So revenue is, the dollar amounts mean nothing. We're relying upon the fact that number one, as far as accurate, number one. Number two, percentages is all we're looking for. Second point is that whether or not he is producing wine or selling wine without a license is not a question for this board. That's a question for the board of selectmen and the ABCC licensing authority. So we have nothing to consider regarding that.
Okay, but I would just state in the zoning bylaws, if he's manufacturing it at 16 East State Street, he's violating our bylaws. Because if you're manufacturing there,
Again, we're not searching for violations. That's
Okay.
the job of the zoning administrator or the building.
well, I would just stick in the zoning, that's all.
I hear a lot about, 11 acres of hay versus the 15 acres. Is there any state statute that says a farm needs to be profitable? Or a farm needs to turn a profit? I mean, what I'm getting at, to me, it's irrelevant whether he bales the hay and sells it for 50 cents a bale or $5 a bale. A farm's a farm's a farm. That's where I'm going with this.
Sure.
I mean, I can have a class 3 junkyard license and not sell any parts, but still be a junkyard
Right, right.
without selling parts. So is there any state statute that says the farm needs to be profitable, and needs to sell their product to make a profit, and if they don't, they're not a farm?
No.
Okay, thank you.
Similar to that, if I may, as I asked both attorneys regarding this question, what are the ramifications of this board considering whether or not making a determination as to whether or not this property, or specifically the tasting room, is protected under Dover Amendment?
So, Mr. Chairman, you and I have had this conversation, but obviously hasn't been shared with the board because we had the conversations outside of an open public meeting. The matter before you is complicated. That I'm telling you anything you don't know already. There's a lot of moving parts. In its simplest form, what has been requested of you is to overturn a decision issued by your building commission. That decision is a letter, we refer to it as the missing information letter because that's the title at the top of the page. And it identifies a number of issues or problems associated with the use of what we've been referring to as the tasting room. 5 in particular. 3 of those 5 were building code related, and so they're not for you because they've been resolved, first of all. Second of all, even if they hadn't been resolved, they wouldn't come to you because building code issues go to the State Building Code Appeals Board if they're challenged. So the 2 issues that remain of those 5 are the issues that are coming before you. There are only 2. Issue number 1 is a statement, and I don't want to quote it wrong or incorrectly, so I'm going to just read directly from the document itself. So the first one is a statement, and again, I'm going to read it verbatim. After reviewing the permit application submitted May 8, 2025 for change of use at 16 East Street in Granby, I would like to remind you that a site plan review by the planning board is still required. Please get on the planning board's agenda as soon as possible to resolve this. So that's the first question. Is site plan review required for the change of use of this tasting room from what it was before, which I understand to be some sort of storage building, to what it is now, which is a tasting room? So that's question 1. Question 2 is actually the last of the 5 items in that same letter. And again, I'm going to read it verbatim. It says, it's a couple of sentences, 4 sentences. It says, lastly, I have found a special permit issued for a garage/storage building exceeding 1,000 square feet in area. This was attached to the deed. It stipulates that no business or industry is conducted therefrom or therein as defined under zoning bylaw accessory uses. I was not able to find any appeal indicating a change to this restriction. Please provide this, and if not, appeal to the ZBA within 30 days. So this is the second question. This special permit, which we now know is a permit from 2010, that refers to this building, now the tasting room, previously referred to as a garage or storage building. There's a condition in that special permit that says no business or industry conducted. Does the current use constitute business or industry? So those are the 2 issues before you. Now you might be asking, well, okay, thanks for telling me that, but that wasn't my question. My question was, can we address this Dover Amendment issue? Is it properly before us? Well, that's not really what's before you, but I think it's, to use the adage you did a bit earlier, I think it's the elephant in the room. I'm not sure how you address, and I'm not sure that the applicant's counsel or the neighbor's counsel or anybody else in the room knows how you address these issues without delving into this topic of agricultural use. That's why the very first correspondence you received from Attorney Durning on behalf of the applicant, within the first page of that correspondence, went right at this as an agricultural use that's protected under the Dover Act. Same thing with counsel for the applicant, for the neighbors, arguing the opposite of what was presented by the applicant. So I think for you to determine whether or not this use is a use that requires site plan review, for you to determine whether that special permit restriction on business or industry is applicable, I think you have to determine whether or not the Dover Amendment applies. And that in and of itself has multiple parts and is a confusing inquiry. okay, well, for the Dover Amendment to apply and to supersede any restrictions or provisions of your bylaw that might establish other standards, you have to determine first, and this is what you heard from Attorney McLaughlin, first, that the primary purpose of the use of this property, and let's just say the property for now, is commercial agriculture. Okay, so that's question one. And then number two, you have to look at this tasting room, this component of the operation, and say, is that part of that? If you determine that yes, the primary purpose of the property is commercial agriculture, is this tasting room part of that agricultural operation? If so, and if that agricultural operation is the primary purpose of the site, well, then it's protected under the Dover. But even if the primary purpose of the site is agriculture, if you determine that the tasting room is not part of that agricultural operation because what's occurring within the tasting room is not agricultural, well, then you have to determine whether it's accessory to agriculture. We talked about that at the last meeting. I gave you the quote from a land court case that talked about the definition of accessory use. It's customary and it's incidental to the principal use. To put it more simply, you have to find a nexus, a connection. Connect the dots from the accessory use to the principal use, the primary use. Is there a connection between the two that is strong enough that it can be deemed accessory to the principal use? And if so, even if it's not itself agricultural, it can also fall under the protections of the Dover Amendment. So I think it's difficult for you to ignore those questions. I know that there have been some procedural issues raised. I'm not speaking to those right now. I'm happy to speak to them. We talked about the timeliness of this application. We talked about the letter that was issued back in 2024 by Damien Cody, the former building inspector. Those are procedural issues that go to the very question of whether this issue is properly before you. Putting those aside for the moment and assuming, just for the sake of argument, that this application, this attempt to overturn the May 31st letter is properly before you, that's the analysis you need to perform, I think, in my opinion. You have to first look to the agricultural exemption, the Dover Amendment, determine how and if it applies, and that will inform your decisions on these two provisions of the letter and whether these two provisions should stand or should be overturned.
Thank you.
Mr. Chairman, thank you.
Go ahead.
So to clarify, and I'm not, there's a lot of stuff going on, whether, the entertainment, whether you agree with it or disagree with it or whatever, but to clarify, the two questions before us is a winery agricultural, is haying agriculture, is that agriculture? And if it is agricultural, that's not an industry, that's not a business, so that's kind of get what you're saying is that or am I struggling here?
No, I think you're struggling a bit. So I don't think, and I will tell you as a matter of law, a winery is agriculture, right? The case law says wineries are agriculture.
Correct, I read that.
But it's actually a little bit more nuanced than that. Is the primary purpose of this site, this property as a whole, is the primary purpose of this site commercial agriculture? Now that can be a winery, that can be haying, that can be farming for growing corn. It can be any type of agricultural operation or aquaculture or horticulture, any of the things that are captured by the statute. So question one is the primary purpose of this site agricultural, even putting aside for a moment the specific use of the tasting room? If your answer to that question is no, I think the inquiry ends there. It's not protected under the Dover.
Correct.
If your answer is, well, yes, the primary purpose is agriculture because we think there's enough hay or there's enough of agricultural operation occurring on the site, well, then you focus in on the tasting room. Okay, that's great. So the primary purpose of the site is agriculture, commercial agriculture. What about the tasting room? Is that part of the agricultural operation? If so, you're done. It's protected by the Dover. If you're not so sure, because you say, well, there's no agriculture going on in the tasting room, or we don't consider what's happening in the tasting room to be agriculture, and that's an analysis you have to make. Well, then that doesn't mean the inquiry stops there. Then you have to say, yeah, but is it accessory? Is it sufficiently related to the agricultural operation that we can say it's permissible under the Dover Amendment?
Thank you.
To further clarify that, your original statement was there were basically two questions before us. That is based upon the first 4 paragraphs, on the missing information, quote unquote, line. And that has to do with the site plan review requirement. It's the fundamental question, right? And then you're talking about the last paragraph regarding the special permit issued in 2010, So could you please clarify for the board, do we vote to uphold that or reject that, or can you give us some guidance in terms of how we deal with that problem?
With respect to the business or industry reference, is that what
That's
you're talking
right.
about? Sure. So the ZBA issued a decision, as I understand it, a special permit, I have it somewhere in my many papers on this case, that had this restriction to business or industry with respect to its allowance of this garage/storage building. If the garage/storage building, now the tasting room, is being used for an agricultural purpose, either because it is itself part of the primary agricultural purpose on the site, or it's being used in a manner that's accessory to that, I would say that, and this goes to something that was said by one of the residents about the fact that in most instances, and I'm gonna add a bit of nuance to it, in most instances, when there are conflicts between state statute and your local bylaw, the state statute controls. There are some instances where the state statute can serve either as what we call a floor or a ceiling and allow you to provide greater or lesser protection because that's how it's worded. But in most instances, when there's a true conflict, state statute controls. And I think that there's a little bit of that in this case. You have a bylaw that talks, for example, I already heard it referenced today about farm businesses and has this 50% standard. I don't think that's particularly relevant in this case because the parties aren't arguing that the farm business standard is what applies. They'll correct me if I'm wrong, but I don't think they're arguing that this is a farm business or that provision of your zoning bylaws is what they're attempting to latch onto to gain protection. They're citing the state statute. And state statute doesn't establish this 50% test for a farm business. State statute talks about agricultural uses. It does talk about the sale of agricultural products on a site that is dedicated to agriculture. That's when we get into these percentages, and I'm going to withhold my comment on that because I have some thoughts as to whether that's even relevant here. But there is some mention of that in the state statute. But this is a Dover Amendment case, as I understand it. And so if you've got a provision in a decision from 2010 that restricts the use of this building to no business or industry, and the business or industry that's occurring is an agricultural business or an agricultural industry, I'm not sure I got an agricultural industry, but is agriculturally related, the state statute controls. And so, in my mind, if it's determined to be agricultural, then that restriction is no longer applicable. I don't think it requires action by this board to rescind the restriction of a board 15 years ago. I don't think that would be appropriate in these circumstances. I think that was referenced maybe in attorney during the submittal, that would be an alternative avenue for the board would be to overturn the decision, or reverse the decision of the, I guess in effect that's what you would be doing by virtue of stating that Mr. Quinlan's decision was wrong. But again, it wouldn't even be quite saying it's wrong. It would be saying we've made a determination that the use is agricultural or is accessory to agriculture, and therefore we've determined that this restriction in the 2010 special permit is not applicable to the use of the tasting room if it's being used for this agricultural purpose. But again, I just made a bunch of assumptions there. You would have to make all those conclusions or reach all those conclusions before you would get to the point of invalidating, in effect, the 2010 restriction.
Thank you for clarifying those minimum.
My apologies. Is it still open to the public? Have we moved? So we're ready?
It is.
May I speak?
1 second, please. Go ahead, sir. Your name and address, please.
My name is Mal Lukoviak. I live at 16 Phillips Circle, Granby, Massachusetts. I've lived in Granby since 2015. I lived at 109 Pleasant Street. And I work as a physician assistant at Bay State in cardiac surgery. So it's highly likely someone here has a direct relative I've taken care of. And I'm citing all these things because I'm trying to explain that I have a deep connection to this community. I chose to build in Granby because of the character of the town, of the involvement of its citizens, and I also, about 2 years ago, came up against the town when it came to building our new home in regards to having an in-law suite for my mother-in-law to live with us. Damien Cody, who's been, I think, cited as having made a decision, I think, based off zoning bylaw primarily, and administered a cease and desist. He similarly went down the same avenue against us, and ultimately that was found to not be the case, that his interpretation of the zoning bylaw was correct. And I think that is important to know because he's not really here to explain it further what he was actually trying to do. But in my interactions with him, a lot of things were done off the books. Now, this all being said, when I live 2 streets away and can hear music off in the distance, I sometimes wonder why there is, or I understand why there is so much fascination of the disturbance. And typically I'm in this deep meditation back when I'm building my house, and my generator, which has to be louder than any music anyone's playing, with the exception of my neighbor who's leaf blowing his dog excrement onto my property, is I just get thrown off. You know, what if my sons decide that they want to play an instrument, and is this what I'm going to have to come up against time and again to try and support them? The Winehouse is congruent with, in my interpretation, of course, this is a complete appeal to the emotion, and you know, on top of the rationality of it all already, and ad hominem against the previous building commissioner, but it's congruent with the character of the town. And to see things like this, something so novel and, you know, in my opinion, exciting and a place of gathering, is important because I have 2 sons who have special needs, and I somehow find myself living in a town with the second most underfunded pre-K system in the entire state. I can move to an inner city 20 minutes away and we get more services for their individual educational plans. I have a tough time wondering about the future of our town if we are not diversifying our tax base, if we're not encouraging places like farms who are going to be innovative and come up with different ways to be able to establish more funding for the school system, for the services we need, and refocus the trajectory of Granby, and kind of get with the fact that we need more resource stewardship, a little less focus on highly complex septic systems that don't have any sort of research to support, or really scientific basis to support their use. There's other places I think we can really start to grow more as a community. So I want to thank everyone for taking the time to, you know, flesh this out. It's nuance is an understatement. It's incredibly complex, and I wish you all the best in trying to come to a decision that's fair. Thank you.
But also, can you speak to it?
Yes, sir. Excuse me 1 second. So did you sign in the sheet?
I did, yes.
And your name and address?
Dave Cody, 70 Cold Hill Road. Moved to town, same thing, about several years ago. And I heard about this controversy because we stop by, wife and I visit the Winehouse once in a while. We find it to be a great addition to the town. I was quite surprised of all the uproar that's going on, and I understand the residents probably have more issues. I live about Cold Hill Road, and I don't hear the music or anything, but I'd have to say that listening to the arguments back and forth, I think the town, obviously, the more attractions you can bring to your town that bring value, it's going to bring in future residents like myself and others. You can still have that farming community and still but have a little bit of places to go and for entertainment especially, and to have a glass of wine. And I was listening to the discussion about the percentages of grapes and all this stuff you're going through, right? I'd ask you to go any farm stand, including the ones all in this town, and you will not find that 100% of the products in that farm are from that farm. In fact, beneath me, below where my property is Breezy Acres. And Evelyn's got a great farm there, and we love her dearly and support her a lot. But she has things from other farms in the area. The corn comes from Hadley. Tomatoes come from over here. And what the farmers do is they all work together, much like they're talking about Jim, or I guess traded hay for this or whatever. That's pretty common in the farming business. I just wanted to bring that forward. 2 things is that, 1, I don't think you're gonna find a farm stand that has 100% of their products coming from their farm, okay? It's just not gonna happen. And then, and so they all work together like community farming. And I think having some things in the town, I thought the wine house, my wife and I were very happy and opened up to bring something to town, because there's very few places to go for entertainment in this town, you know? So, I think that it's, to the gentleman's point just before me, it's a nuance, it's a farm, he's growing hay, growing grapes, and he's producing a product, wine. And it seems like the wine might be the bigger problem than anything else, the way people are speaking about it, okay? So if we were producing honey, we may not be having this discussion or something, you know what I mean? So I don't know, I just think that it's not gonna, I think you can have a farm, it can be a farm stand, you don't have to have 100% of your products come off your farm, and I just think it brings a lot of value to the town. That's my, I
Thank you
think.
for your comments. We appreciate our position, where we have to make black and white decisions out of shades of gray.
What's that?
I said, we have to make black and white decisions out of shades of gray.
Yeah, that's a challenge, I agree, yeah.
I think that's number 2 again.
Chair, may I ask a question through you of Attorney Costa?
Yes.
With his resignation?
Yes, go ahead.
Attorney Costa, I thought you referenced a statement that the winery itself was agricultural. Does that matter as to whether percentages of grapes going into the winery are from the appellant or not? Just, he could build a winery there and take grapes from California, and that would be agricultural?
No, that wasn't, through you, Mr. Chair, so that wasn't the point of the statement that I was making,
Okay.
that you could bring in grapes and essentially create a manufacturing operation on the site, call it a winery. The point I was making is that throughout Massachusetts, you've got true wineries, where you've got vineyards that are operating vineyards, and you've got tasting rooms, much like what is suggested here, that are operating as part of that winery operation overall. You know, when we talk about percentages, I want to use that as sort of a jumping off point, because we spent probably more than 50% of this time discussing tonight these percentages, 25%, 50%. I just wanted to put that in a bit of context, because understandably, and as Attorney McLaughlin acknowledged at one point in his remarks, that this section of the statute, this provision of the Dover Amendment, is incredibly complex. I think it's a single run-on sentence of something of like 330 words, with a horrid amount of punctuation in some instances where it doesn't belong. So it's very difficult to interpret the statute. But in its essence, what the statute does is it protects agricultural operations that are commercial in nature and are the primary purpose of the site in question. It then goes on to say, after it lays that out, and I've got the statute in front of me, so it talks about specifically, nor shall any such ordinance or bylaw prohibit, unreasonably regulate, or require a special permit for the use of land for the primary purpose of commercial agriculture. But then it goes on to say, including those facilities for the sale of produce, wine, and dairy products. And then over the course of the next 15 lines in the statute talks about this 25% test. It's going to be 25% of the revenue or volume of what's produced occurring during the primary growth season of the principal crop. Or as an alternative, you can go with this 25-50% split, where 25% is on an annual basis, where 25% is from the owner or lessee of the property, with an additional 50% being from other Massachusetts farms. These provisions concerning percentages, 25% or 25-50%, they apply to, this section of the statute is often referred to as the farm stand section. It is separate and it follows the general protection of commercial agricultural uses, and it's really aimed at farm stands. Again, facilities for the sale of produce, wine, and dairy products. So certainly you can take all of that into consideration if, and only if, you are considering, and I know that this is an argument that Attorney Goering has made, if you're considering the use of the tasting room to be, in effect, a farm stand, a facility for the sale of produce, wine, and dairy products. Now, it can be characterized as that, I suppose, because that is, as I understand it, partly what's occurring within the tasting room. I also understand from some of the submittals I've seen that the objections about what's occurring in the tasting room is that arguably it does more, it's more than just selling produce, wine, and dairy products. It's hosting the functions, they have an entertainment license, they have food trucks on site, so there are things of that sort that have been brought up as well. So I just want to be sure that when you are talking revenue numbers, that if you're applying the revenue numbers to the tasting room specifically, it's because you're considering it a facility for the sale of produce, wine, and dairy products. That wasn't quite fleshed out when we talked about this 4 or 5 weeks ago. We were talking about revenue numbers, and the board specifically requested revenues or percentages from the applicant. But my understanding anyway, leaving that meeting, was that the primary, the objective of requesting that information was you wanted to use it in a more generic sense to decide whether or not this site as a whole was being principally used or primarily used for agricultural purposes, or whether there was other revenue generated with the site as a whole that was going to cause you to reach a different conclusion, that the site was being used for something different, that much of the revenue generated from the site was from events that were being conducted and hosted on site, or bands that were playing on site, or food trucks that were being brought to the site, as opposed to the actual agricultural operation. So you can use the numbers in that sense, much more subjective. There's no numerical or objective standard in the statute for you to look at those revenue numbers or percentages and apply those to the site as a whole to say, is the primary purpose of this site commercial agriculture or not? If you're going to apply the 25 and 25, 50% rule, you're only doing that if you're considering this tasting room to be essentially a retail operation for the sale of produce, wine, or dairy products.
As a follow-up on that, going back to the fundamental two questions. Am I correct in understanding that question number one regarding site plan review would be effectively overturning the building commissioner, and that would require a majority, a supermajority vote?
That's correct. So regardless of which of these questions it is, if you are going to vote to go against the wording, the conclusions, the order that has been issued by virtue of this missing information letter, to effectively overturn or reverse it, it requires either a 4 out of 5 or a 5 out of 5, supermajority vote of a 5-member board.
And what about the second question, effectively reversing a prior zoning board decision? Does that also require?
It does, because again, you're not, I certainly would not advise you to structure it as reversing, and you use the careful word effectively reversing, right? Because while you are effectively reversing, that's not how I would recommend that you phrase your motion. If you determine, for example, that this was an agricultural use, and therefore, as an agricultural use, that this restriction on no business or industry didn't apply, I would have you take a vote to that effect, reversing the building inspector's requirement that there be some evidence produced or some change of the restriction produced, because you've concluded that there is no change of the restriction, that restriction was ineffectual because it can't override state statute. But that would also require a supermajority vote. Yes.
And what about the opposite of that, is that we decide that that is not a agricultural use? Does that also, I mean, how do you deal with that scenario?
Sure, so you still have the same two questions to answer, right? So if you determine that it's either the site is not being used for the primary purpose of commercial agriculture, or that it is, but that this tasting room doesn't qualify as protected, either as part of that operation or as accessory to that operation. Okay, so you've answered that preliminary question of the agricultural protection is not applying. You still have to answer these questions of, okay, does this use require site plan review? And is this use permissible, or is it restricted as business or industry? I think that I would almost recommend, if you get to that point, and I'm not saying that you should, but if you were to get to that point, I would almost recommend that you answer those in reverse order, because I think if you answer the second one first, as to whether or not business or industry is permitted, and you conclude that based on the 2010 special permit it's prohibited, doesn't that sort of answer your question about site plan review being required? Site plan review of what? Prohibited use that's not allowed there? I don't think that it's much easier to answer that question than if you concluded that it's prohibited use. But again, that's only if you determine that agricultural protections don't apply and that the provisions of the 2010 special permit therefore stand.
May I ask Mr. Costa another letter?
Yes.
I said that's a question.
Go ahead.
Was the issue of the site plan review appealed? Or is that something that's still effective in an order?
So through you, Mr. Chairman, so my understanding, and again, Attorney General's here so he can speak for himself, but in reading his letter, the first of them, and then there was a second and a third, The first letter quickly moved into the question of agricultural use exemption and the Dover Amendment, et cetera. But I found references within that document to both of these provisions, the change of use triggering site plan review, and the belief that that wouldn't be required, as well as this issue of the 2010 special permit. So I view that correspondence as being sufficient enough to put really this whole letter in question. It was a challenge to this missing information letter, that was clear. The other three items here, fire department approval, board of health sign off, and a site visit for, with the site engineer, those were all related to the building permit change of use, and all of those issues have been resolved and the building permit change of use is issued. So those are moot points. But the other two issues, I believe, are very much appropriately before the board.
One more, if I could. And
They're gonna start charging.
I'm sorry. Attorney Costa, how should the board, or what advice would you give the board pertaining to the 2024 order, which might moot the entire
Do you want me to address those issues?
Please do.
Okay. So, so there were two, I made passing reference to these a few minutes back. There were two sort of procedural issues that have been raised to you by counsel, by Attorney McLaughlin. One was the 2024 letter that issued by Damien Cody. And I've got a copy of that here as well because I do want to reference it because I know that there were some questions raised by one of the board members as well. And then the question of the timeliness of this appeal because it was submitted during the week when I understand the town clerk was on vacation. So I view both of these as jurisdictional issues. And fortunately for you as a ZBA, you don't have to deal with jurisdictional issues very often. Courts deal with them all the time, and attorneys love them because we get to resolve cases without having to ever get to the merits because we can win on what lay people call technicalities. Well, those are jurisdictional issues. And so if this case was not filed in time, if this appeal was not filed within 30 days of the May 31st letter, the missing information letter, that's a fatal error. That means it was not timely appealed and therefore was not properly before you and you have no authority to act on it. Similarly, if the appeal is challenging an issue or raising a question that is an issue that had been the subject of a letter from back in 2024 that was not timely appealed, then similarly it would not be properly before you. Unfortunately, in this case, nothing is black and white, as we've already said. I'm going to address maybe the simpler of the two first, which is the timeliness of this appeal in light of the fact that your town clerk was on vacation. The law is clear. When you make a filing of an application that is an administrative appeal, you've got to do so within 30 days of the order that you're appealing. You have to file it with the town clerk's office, and then you have to file it with the zoning board of appeals, because that's the board to which you're submitting your application, typically with a courtesy copy to the building official if you're challenging the building official's determination. That's the proper process. There is case law, I think it was referenced by Attorney McLaughlin, maybe by Attorney Durning as well, I can't recall, at our last session of the public hearing, relative to what suffices for submittal, because as you might imagine, and this happens more the further west in our state you go, when you have smaller and smaller communities that often don't have full-time staff, full-time town clerks, limited town hall office hours. There are often challenges for applicants, for challengers, for their counsel when they show up at town hall and town hall's closed and it's the last day of their appeal period or the day before the last day of their appeal period. There are cases where counsel have hunted down town clerks and knocked on their front door and said, here you go, you're on notice. I don't know all the particulars of what occurred here, although I know both counsel have their own perspectives on what occurred. My understanding from what Attorney Durning had presented last time was that this was meant to be submitted to the town clerk's office, but the town clerk was on vacation for the week. And as a consequence, it was submitted, I think, to the town administrator's office or
The Board of Health agent was the one who stamped it as received at the desk of the town clerk.
I'm going to address that in our preliminary findings when we enter deliberations.
Okay, so I mean, I think the issue there for the board is that sufficient? Does that constitute a filing with the town clerk because the town clerk was on vacation and somebody else stood at the town clerk's desk and stamped it in for the town clerk in the town clerk's absence? For what it's worth, I will tell you, I think that there are two sides to this argument. On the one hand, yes, I guess you could say that's not strict statutory compliance. On the other hand, I think there has to be a recognition that your town clerk can't decide she's going to go or he's going to go on a 2-week vacation. And I don't think this was 2 weeks, I think this was only 1 week. And therefore preclude all appeals because the town clerk was gone. What if the town clerk leaves for 30 days? What if the town clerk is on maternity leave for 4 months? No, you can file applications for 4 months. So there has to be a process that exists to supplant the process that would otherwise be available. And I don't know whether that's what happened here. So I think that those are the flip sides of that coin. With respect to Mr. Cody's letter from back in 2024. It was issued on June 25th. A couple of things. So I think I heard something, a reference was made earlier to you can't appeal straight to court, and we're talking about exhausting, and that's absolutely correct. So the doctrine is referred to as the exhaustion of administrative remedies. You have to exhaust your administrative remedies, your remedies locally before you go off to court. So if you're dissatisfied with a decision, an order you received from a building official, you can't simply appeal that straight to court under Massachusetts law. You have to appeal it first to the ZBA, much has been done here, like what has been done here, and then the ZBA gets its bite of the apple, and once the ZBA decides, well, then it can be appealed to court if the appealing party is still dissatisfied. So notice of violation that issued back on June 25th of 2024 to Attorney Point did say, please contact this office within 5 days of receipt of this letter, so it did suggest that there would be some sort of ongoing dialogue. Again, the flip side to that is that if you read a couple sentences earlier, it says if you're aggrieved by this decision, you have the right to appeal before the Zoning Board of Appeals, and goes on to say that an appeal shall be made within 30 days. So it was right there in the letter, and there was no appeal made within 30 days. So if this were a straight attempt by Attorney Durning to file an appeal of the June 25th, 2024 notice of violation, that's how this was structured, and this had been submitted in June of this year, I would be clearly advising this board that it's not within your jurisdiction. It's a year too late. A year, or at that point it would have been 11 months too late, right? That's not what's happened. What's happened here is an additional letter was issued by a successor building inspector, and the successor letter was termed a missing information letter, and highlighted these issues of the need for site plan approval and this issue of the 2010 special permit not being complied with because of the business or industry occurring within the tasting room. And it also said that there could be an appeal to the Zoning Board of Appeals within 30 days. So the reason we're addressing the agricultural exemption of the Dover Amendment is because I think it's very difficult to address those two issues without, again, addressing the elephant in the room. How do you talk about whether site plan review is required if we don't discuss whether this is entitled to protection under the Dover Amendment? How do we discuss whether that 2010 special permit still stands, that condition stands, if we don't discuss whether this is an agricultural use? So it is, some may say, a backdoor to challenging the decision from back in June of 2024, and I can appreciate that argument. I think the flip side is another letter issued referring to an appeal option to the ZBA, and it's those determinations that have been appealed to the ZBA, and not really a direct challenge to the 2024 letter that was issued by Damian Cody.
Mr. Chairman,
Yes, sir.
just a minor clarification, although I believe you don't salute it, Adam. We did submit a request for a determination to the building inspector on April 25th, 2025. Whether the missing information letter was appropriately a response to that request for a written determination from the building inspector, I think that can be discussed, but there was a procedural step that we attempted to make.
And I don't, that may be true. I don't have any information personally as to whether the letter that was issued by, what was the date on the letter? The missing information letter, the May 31st letter that Mr. Quinlan issued. I have no information whether he was issuing that in response to anything or not, and he's not here to speak for himself. So that may very well be the case.
That I can confirm that that indeed happened, but I'd also like to get clarification regarding, my understanding is you can request all you want, I mean, like that, is that correct? In terms of requesting a determination letter?
So the law, I mean, as you can probably appreciate, the law favors some degree of finality, so that the language the courts have used is that litigants shouldn't have to repeatedly go to the barricades to make the same argument over and over again. What is clear is that if a determination issues and a party that has a right to appeal that determination doesn't appeal it within whatever time frame is provided, in this case 30 days, that party can't effectively restart the clock whenever they want by submitting a request for that same determination. They can't wait 6 months and say, oops, I missed my 30-day window, so now I'm going to just submit a request asking for a determination. I know what the answer is going to be because it's going to be the same answer I got 6 months ago and I didn't bother to appeal it, and then I'm going to appeal it. Then they can't restart the clock themselves, otherwise they could do that at any time. And again, I'm not suggesting that's what has happened here, but your point is correct, that if that is what happened, then no, that would not legitimize it necessarily. But again, the flip side to that is Mr. Quinlan did issue a further letter on May 31st, and it doesn't really address the same issues as Mr. Cody's letter had issued a year earlier. It speaks to site plan review and to a 2010 special permit restricting business or industry. It just so happens that in order to address those issues, we kind of have to look at the use of the site and determine whether it qualifies for Dover Amendment protection.
All right, thank you. That being said, one more speaker, please. Your name and address?
My name's Philip LaFlamme, 12 Phillip Circle, here in town. I thank all of you for taking a minute to listen to me. We bought our home in '09, I think. We've been there 17 years, something like that. Before that, moved to town in '91, lived at 136 South Street. That was 3,000 feet away from the property where the White House is. I'm currently 1,900 feet away. I'm about a third of a mile away. It wasn't brought up a lot at this meeting, but at other meetings that I've watched, people are complaining about the noise. Now, I don't have a problem with it. The trucks on E Street, triaxles, trailer trucks, definitely louder. Airplanes, definitely louder. The train in Holyoke is louder than the music that comes from the White House, and along with the train in Belchertown. 5 o'clock every day, the bass plays their national anthem, or whatever it is they play. I'm not complaining about any of those sounds. I'm comparing them. They are all louder than what I hear at my house that comes from the White House. I can hear some music. Do I know what song it is? I can't tell, because it's too far away. It's not loud enough for me to understand what it is. Has it put a damper on my life? Absolutely not. Not even a little bit. I think the town should be looking for businesses like the White House. And this is totally unbiased because one, I don't drink. You know, I used to. I don't drink anymore. But I have been to the White House. I've never paid a penny for anything in that place, ever. But I've met friends, I've met family there. It's clean, it's new, it fits in this town. It's well run. It's just a nice place. Now, as far as I'm concerned, that's a totally unbiased opinion of mine. And everyone has opinions. And I've heard people that live farther away from the White House than I do complain about their life being destroyed over the music. I guess everyone has opinions. That White House has not bothered me one bit. Living at 136 South Street from 91 to 09, you could hear dogs because that property was a kennel. That was 3,000 feet away. Sometimes you'd hear dogs 24 hours a day, depending on whatever dog they had. That dog's in a kennel, he's pissed, he's barking. We lived Phillip Circle at 12 in 09. It was still a kennel. You could still hear the dogs. You could hear the dogs 100 times more than you ever hear music from this wine house. The wine house has brought car shows for free with no admission. That's great. I'd love to see them get bigger and better. The little bit of music is off before dark when they do have it. I think this town should be looking for more businesses like that to offset taxes. Instead, what I see from the outside is a business trying to make it and running into hurdles that should not exist. I think this is it should be just a non-topic. The guy should run his business, and Dakota, you know real estate. Bill, I don't think anyone knows towing more than you. Both you guys know I grew up on a farm. I know farming. And if they want to angle on the percentage of crops, I'll give you two things. The percentage of crops coming out of the ground and go after a farm like that, you might as well shut every farm down in this state. Because farms get products from other farms. And do you think when you can't make money in the winter, you're selling Christmas trees? Do you think the farm grew the Christmas trees when they don't have a single one on their property? And I do know, looking from the outside in, the White House planted grapes. I've seen apples. I've planted them. You don't get apples for 3-4 years. This guy's not gonna come up with this product like out of nowhere. And then the angle that they're whacking this guy with is just absurd. He's a growing business that's trying to make it in this town. Why they have to go after him? I don't know. But it's a hurdle he has to go through, and I hope you all decide in his favor, because I think it's a good, clean business that people come from other towns to go to. Without business, we'll have no tax offset ever. I think that's about all I have to say.
Very good. Thank you for your comments. And have you signed in, sir? Excuse me? Yeah, you signed. Yeah. Yes, sir. Name and address, please.
Nathan Laflamme, 286 Taylor Street, Granby. So first I want to thank the board for your community service. It's a thankless, unpaid job, and I understand.
We don't get paid.
But I'm sure every one of you joined for the same reason. You wanted to better Granby. And I understand that. And I know one thing that betters Granby, and it's the Wine House. I speak for the silent majority. In the silent majority, the thousands, if not tens of thousands of people that have visited the Wine House have left with a positive experience and good memories. Thousands of people, they're just not here tonight because we live our lives humbly. We don't come to every damn town meeting and bitch about everything. We don't. We live our lives humbly. But when you poke us enough, we'll come here. And that's why I'm here tonight. It's because the Wine House is a good fit for Granby. It's awesome. I visited maybe 100 times now. I love it. It's great for Granby. If anybody says different, I'll buy them a damn mirror, because that's what they need. In regards to farming, just like my brother said here, you better go after every single farm in town, every single farm in the state. If you want to go down and get caught in the weeds over percentages, hops, Merlot, Pinot Grigio, whatever, get caught in the weeds, whatever. Back up though and look at the main focus. Is the state has a farm winery license for a reason. You can go right on MassGov and read it, why they did it. As with many other farm wineries in Massachusetts here, they're following the same exact rules. The Wine House is doing nothing different. Now you can go down the weeds and get caught up and wrung around the axle and talk about percentages, hops, and this and that. But at the end of the day, good luck in court. None of it will hold up. Because you know what? I am a farmer. I'm a farmer in this town. And you know what? If you come after the Wine House, come after me too, because you know where my pot comes from? It comes from North Carolina. You know where my peat moss comes from? It comes from Canada. You know where my cuttings come from? They come from Georgia. Good luck. Every farm subsidizes in some way. Absolutely, yeah. I'm not talking about marijuana.
I just want to clarify.
So at the end of the day, are we in wine country here? No, we're not. Absolutely. Are we in Napa Valley? No. Absolutely not. Do you expect the Wine House to subsidize with California grapes? Absolutely. Hell yes. There ain't a winery in Western Massachusetts that is going to do this on their own. And you guys, I want you to back up. If you try getting caught down the axle with some of this crap that's been said tonight, it's bullshit is what it is. And at the end of the day, good luck in court. I thank you all, and I know you'll make the right choice.
Mr. Chairman, we had a couple of final questions and all. There were some things brought up, and I don't know the attorney. From what I understand, the entertainment to me is like background noise, but that's been a big thing there. Everybody saw our revenue. I don't believe there's any ticket sales for any of those events. Everything's free, I believe. Okay.
Yeah, thank you. I appreciate the opportunity to respond. Yes, and it doesn't show in the revenue data.
That's what I thought, okay.
Because the music combos that play or the special events that occur, and we gave you a sampling of them from the last few months in our October 28th those are not revenue generating for Winehouse. I mean, I think as some of the folks, I'm a little jealous. I think they were more eloquent than I was about what's at issue here. But those entertainment avenues are really innovative ways to bring folks together, get them in the door, and you see from the revenue sales, what is sold is the product that Winehouse produces. It's the wine. And I just take issue with the Richardson case where you had somebody who was, extracting a lot of gravel and sand and selling that, and that was the primary use. What we have here, based on the revenue figures that we gave you, and we tried to be as transparent as possible in delineating the specific percentages from the wine that was derived from grapes grown on the property and wine that was produced on site, but from grapes that were off site. Overwhelmingly, what is sold is the wine produced by the wine house.
Mr. Chairman, that's my next question, and then I'll be done, is there's 15 acres of the farm. 11 of it is hay, if I understand.
Right.
Hay. How many acres are grapes?
I don't have that figure off the top of my head, just around 2.
Okay, so I've been doing some research, and 2 acres of grapes will produce between 6,200 bottles and 8,000 bottles of wine per year. So that's a lot of wine. Thank you.
Yes, for certain. That's fine, sir.
Sorry. Back to let's go back to the site plan review portion of the application. I know that your position, or Mr. Trompe's position, primarily is that zoning doesn't apply, assuming that you are qualified for the overlay permit. But I would beg to differ on that to a point, because it doesn't say that specifically. It says special permit, but really what it says is unreasonably regulated. And in my view, that the only method you can reasonably regulate is to follow whatever guidelines the planning board in this case would use to establish conditions for public safety and things like that. So my question to you is this. Are you still, or is Mr. Trompe still of the position that site plan review is not required at all or prohibited in any fashion?
Mr. Chairman, I think you asked me that question directly towards the end of the last hearing. And at that time, I had said in deference to you that we would not necessarily fight that. And that I don't disagree with you that a site plan review process that is not a site plans review special permit process could be an adequate regulation that wouldn't necessarily in and of itself violate Dover. My understanding is that the property has been, it did receive its certificate of compliance, and it has gone through in cooperation with the building inspector. And from my understanding, it's a dialogue with the building inspector about what remained to be addressed, if there was anything to be addressed with respect to the site plan review of the, was for the installation of certain ballards in the parking lot for those protection purposes. The long-winded way of saying I defer to you that yes, I think that can be distinct, but also an acknowledgement that the Wine House has been working through that process with the building commissioner.
Thank you, and I appreciate that, and I appreciate Mr. Trompe's cooperation with the building official to work through these various issues. My point is simply this, is that going through the site plan review process, if in fact, because you haven't done it yet, so you don't know what the conditions that might be asked of you, but obviously your client still has recourse, because if he believes that the requirements are excessive or something like that, his recourse is to come back to the zoning board of appeals to abate or change those requirements. So I would encourage you in cooperation with that. The other question I have is the question coming back to the elephant in the room, all right, regarding the special permit 2010, upholding that or reversing that from the previous zoning board of appeals. So my question, I guess, is this. How can you explain or how can you describe the difference between a farm stand and, let's say, a nightclub or a restaurant or something like that? Because on the face of it, when you walk in, my understanding, and I haven't been there, so I don't know firsthand, but I mean, it's tables and chairs, and they are serving alcohol, which is permitted by the licensing authority. So how do you compare that directly to a farm stand, which I think in general people would look at, see bins of vegetables and they'll check out and that would be the end of that.
I mean, I think I'd point you to the Town of Natick versus Modern Continental Construction Company case, which did have a very robust farm stand operation that included restaurant services as part of the operation. And the SJC, in reviewing that, was very comfortable in saying that all of that was effectively part of the farm stand operation. Again, from my perspective, I think it is the matter of the point of sale of the agricultural good. And although this setting is different from getting a U-pick bushel basket to go onto the field, or perhaps as you're describing, a more traditional farm stand where you walk up and you can see all the produce laying out and you select it and purchase it, I think that there have been many instances, Modern Continental Construction being the most prominent one perhaps, where the farm stand operation is more robust than just, grab a dozen eggs and leave $5 in the barrel. I think that they are all versions of the same thing, and I don't, again, I bristle at the nightclub connotation in that look at the revenue numbers. What is being sold is wine. And so the interaction with the customer is selecting a wine, and it's, based on its agricultural attributes and the like. That is why I think the tasting room moniker is much more accurate in terms of the interaction that is there, and what the customer is receiving is very directly the purchase of a good that has been produced on and by a farm. And that's why I think the description of that as a farm stand is accurate. The produce that folks are acquiring or purchasing when they go there is the wine produced by Winehouse on site.
One of my concerns is this, is that in our zoning bylaws, and let's assume for the moment that we're not discussing any over, the zoning bylaws currently expressly prohibit restaurants, bars, nightclubs, and things of that nature in the RS district. And my concern is simply this, and I promise this will be the last idiom of the evening, and that is, if it walks like a dog and quacks like a dog, is it really a chicken in disguise?
Fair question, but again, I think the overall context of this operation is relevant. And with although I agree with Mr. McLaughlin, my recitation of the other licenses wasn't to say the existence of them necessarily trumps the zoning consideration, but I was pointing to them, one, the entertainment license, just to give this board comfort, because we had talked about it before, that there are other avenues for regulating some of those aspects. But I do think that the emphasis on this location being deemed by the licensing authorities as a farmer winery is significant. And so the context that we're talking about is, by its nature, whether it quacks like a duck or walks like a chicken, whatever yours was, I think you can't conduct that analysis to understand what the whole mise en scène is of this operation without understanding it is the point of sale of wine produced by Winehouse on a farm that is under active cultivation, and that the primary purpose of the property is for agriculture. Even setting aside, as your question framed, whether or not Dover applies to that, I think you have to understand the dynamic of the location in that context. And again, some of the images that I was sharing before, yes, there's the serving area that's also outside. When those folks are there, they're looking out over the fields, right? That's all part of the same dynamic and what Winehouse is offering, and what some of the commenters have said is such a refreshing amenity that's being offered in the town. So I had a land court argument once where the judge said, and if I was a Martian, came down from my spaceship and I stood in this location, what would I discern? I'll grant you, to some extent, if you stripped away all the context, would you stand in that room and say, oh, this is a bar or a restaurant? Perhaps you would come to that conclusion. But I think what is before the board is all of the context. And all of the context for this operation is that it is located on a 17-acre farm, that it has active cultivation, that it is producing the wines on site, and what it is vending, what it is selling, is the produce of the wine that's there. That's all part of it, and that is very distinct and distinctive from just a generic bar or nightclub.
Thank you. One last question I can think of, and that is, when you're having these events, you're conducting retail sales. In other words, the patrons are purchasing bottles of wine at that point in time.
Yes.
Can you give some perspective in terms of what other sales are being done? In other words, are you selling the wine wholesale to restaurants or other places?
So, yeah, we included in our papers that the operation does have a license to transport alcohol as well, and there are some degree of the sales are not just at the Winehouse location itself. There are retail sales we've mentioned the farm stand associated with Barstow has some of the product there. So there are other points of sale. Does that answer your question, concern?
I'm just trying to get a perspective in terms of, is it 50-50? Is it mostly the outside?
I think for the point of sale for most of the sales are at the Winehouse itself, but there are the license also entitles them to sell a bottle of wine that someone may then take back and enjoy at their house. It's not all the consumption necessarily occurs there, but I think the large proportion of the sales activity are associated with the location. But the bottles are for sale, and folks can take that for private consumption, just as you would, say, at a farm stand, grab those eggs and take them home and use them.
Do any members have any questions of Attorney?
No, sir.
Thank you.
Brother counsel was talking about, when you asked him about the point of sale, actually selling the stuff on site, talks about a case where the court allowed, as under this farm stand, like a restaurant on a particular, I forget the name of the case, but I read the case and I'm familiar with it. One of the points I want to make about that case is that the percentage of food that was being sold at the restaurant, they looked to the actual percentage that was grown on the property. They did look at that. They didn't just say, oh, you got a restaurant on your farm, that's nice. They looked at the percentage. Here you should look at the percentages of grapes that go into the wine. You can't just say, I make the wine here. Now I hear people saying, well, the farms break the law anyways. I mean, being advised to break the law is really a complaint against the legislature, not against this board. This board has to obey the law. And if they don't have 25% of grapes going into the wine, they're not in conformity with 48 Section 3. And the other thing about the case Brother Counsel talked about, that was from a 200 or 300 acre farm. The restaurant was smaller than the farm. Even though the situation is different here. We really have this business being bigger than the farm. And when I talked about using numbers, dollar numbers, it wasn't necessarily for these percentages of what is in or not in what's being sold. Those things, true, it can be by volume or numbers. What I was talking about, the Richardson case, said look at dollars when you're trying to figure out what this property really is. If he makes most of the dollars from the wine, then it's basically a restaurant. If he makes most of the dollars from his farm, then it is a farm, and the winery is helping the farm. It can't be the other way around. I bring up an ice cream case that I cited in my brief, and in my first letter, was ice cream stand had cows, but they didn't have enough, so they were getting the milk from Connecticut, and the judge said, come back someday. You're gonna lose now, because you don't have the proper percentages, but come back someday when you have more cows, and you're selling enough milk to make your own ice cream. We're just ignoring that, seemingly, at least that's what Brother Council's asking us to do, and some of the people are saying, ignore the law. You shouldn't be ignoring the law. Their complaint is not against you, their complaint is against the legislature. Maybe the legislature should change this statute, or at least cut the first sentence into a few more sentences, But I'd ask you to try to obey the law. The percentage, this is not primarily agricultural, it isn't. When he says produced on site, when he's confusing you, produced on site, he means manufacturing wine. Produced on site is the small percentage of grapes that went into it, and that's not enough to get the agriculture exemption. Thank you, sirs.
Mr. Chair, I don't necessarily want to play ping pong here, but just quickly. I don't think anybody was asserting that what farms are doing is illegal. That was preposterous. I think the comments were saying that farms, not that they're doing something illegal, that they need to hustle, that they need to maximize every opportunity and let nothing go to waste. That's much more a farming ethos. And in this context, again, I think it's important, Attorney Costa has framed this fairly well for you, but I think the frontline question that you can contend with is this property primarily in agriculture? And that's why at the start of the comments today, I did direct you to the images that we provided for the full span of the property. And although I acknowledge I think you've talked about being in gray areas, and Attorney Costa has talked about this being an interesting case. There's a very large amount of acreage, 11 acres, that are hayed. And as it turns out, there's not a sale associated with that. But I do think it's an important consideration in terms of where this board can land in terms of finding that frontline question of, is this a property that is primarily engaged in agriculture? I think you need to give serious consideration to the overall nature of the uses of the property, and that significant acreage of haying is a significant consideration. I just remind you of that. Thank you very much.
Mr. Chair, yes, can we move to close the public hearing and move to deliberation, or?
I think we can do that.
I will second that.
Any further discussion on that motion? All right, at this point, we will close the public hearing, public comment, and the board will begin its deliberations.
Would we be able to take a recess first?
We can take a
5-minute recess.
Mr. Chair, can you entertain a voice vote on that?
Oh, yes.
Yeah.
All right.
Thanks.
Thank you. So all those in favor of closing the public portion of the public hearing?
Aye.
I'm going to go back to help Steve finish up. Oh, yeah. I'm hoping to come down there a little bit. I think they're captured. Yeah, I think there are ways of keeping using it.
Oh, she is.
That's like someone stealing someone else's.
She wasn't even select for me.
Purpose to give people heads up.
DOT about it, and she had known that it was traditional about it, she just said so. I will be, yes, she will.
Is everyone back? We will continue now with the deliberation portion of this hearing. What I'd like to do before we get started is that we should outline the procedure on how we're going to do this. And I think that we're going to do some preliminary findings first, so we can set the ground rules. And those preliminary findings will be, I'm sorry? Oh. Okay, sorry. That's why I asked the question. Thanks, Chris. We have just started the deliberation process, and we're going to do some preliminary findings so that we can set the groundwork and perhaps answer questions prior to our deliberations on the two questions. So the first preliminary finding I'd like to address is to address the concern of the question is the notice of appeal timely. The notice was received by the Board of Health clerk on June 20th, 2025, initially received. And that's because the town clerk was indeed on vacation until I believe it was the 7th of July. And the packet was turned over to the town clerk on that day when she returned. And the final application was received on September 24th, 2025, which included the actual formal application together with the fee for reimbursements and the butters list. In my view, as Attorney Thompson mentioned, there's some case law regarding that. And my suggestion to the board is that we deem that the notice has been appropriately filed timely. Are there any questions regarding that? Then the chair will entertain a motion to determine that the notice is filed timely.
Well, I guess I do have now a question, Mr. Chairman. Point of order, I mean, that sounds like that was more of a legal question that I don't think I think for sake of argument, we just assumed it was submitted properly. I don't think we have to take a formal vote. I guess I'll ask through you, Mr. Chairman, as the council that question, whether we should take a formal vote on that. I mean, I think it goes without saying, we're entertaining, we assume that we're saying it was submitted properly, and that's something that somebody wants to challenge down the road, that's, I don't know.
So I think that's correct, that if you were to simply proceed to the merits of the case, then it would be implied that you found the application to be timely. Certainly, if there were to be ensuing litigation, although a review of this board's decision would be what the court's called de novo, in other words, they look at the facts anew as if this proceeding never occurred. Despite that, there would still be a record of this proceeding, and so anybody who wished to inform him or herself would review the record and would understand that there had been discussion about the jurisdictional issue. The flip side to that is that I don't see any harm in addressing it head on. It certainly isn't raised in multiple meetings, and so if the board wants to make a clearer record, I mean, what I would recommend at the conclusion of this process is that you, whether you want to defer this task to me or the chair or another member to be reviewed by me, you're going to have to craft a written decision. You can decide whether you want to put yourself on the clock tonight by voting yea or nay on the ultimate questions before you, and then you're on a 14-day clock for the decision, or whether you want to seek further time from the applicant and schedule a further meeting to review the decision before you officially vote it. But my recommendation would be minimally that this decision address the jurisdictional issue, because it has been raised and has been discussed in multiple meetings. Whether you want to make a motion to that effect is up to you.
So it's not, there's no harm to do it?
There's no-
Okay,
there's-
so I will make that motion.
It's part of
Mr.
the
Chair.
explanation of doing this, that if there was something being contested in the future, one way or the other,
Yep.
is that the person reviewing this would understand our point of view that those questions
Yep,
were raised.
Yep,
And,
okay, with that being said, Mr. Chairman, I'll make a motion that I feel this is deemed appropriate.
For time. Okay, is there a second to that motion? I'll second that. Any further discussion? Hearing none. All those in favor, please say aye. Okay, the second is a determination on the so-called missing information letter. And I think that offers some great discussion regarding from both sides, but in effect, that the notice is not a notice of determination. Only a letter, basically, a memorandum of understanding.
That was the first letter, or the second?
No, the second
The
letter.
second letter
From Tom Quinn.
is the missing information.
Right, exactly. So I will entertain a motion to deem that the missing information letter so-called is not a notice of determination.
I make a motion that the letter that Building Commissioner Quinlan issued is not a letter of determination, but instead a letter of understanding.
Is there a second to that motion?
Second.
Mr. Chair, before you call the vote, so I just want to be sure the board understands, and frankly, that I understand what it is that's being moved. So the missing information letter has been appealed to you, effectively meaning that it has been treated by the applicant as an order of some sort, a violation notice, a letter of determination, a notice of determination, as you've called it, cease and desist order, zoning interpretation. There are different terminology used to describe it, but it's been characterized by the applicant and thus appealed to you as a sort of appealable order issued under Chapter 48, Section 7, which is the provision of the State Zoning Act that gives building officials, as the zoning enforcement officers, the right to make these determinations and issue them in writing, and they then become appealable. If I understand your motion correctly, to determine that this is not a notice of determination, I think that tonight's proceeding stops there. I think if the answer is it's not a notice of determination, that means it's not properly before you, it wasn't properly appealed, we're done. There's no, you wouldn't get to the merits of the case that's before you, because you will have determined that the appeal was not properly brought before you because it was not an appealable letter.
Yeah, but Mr. Chair, that was not my intent. Okay,
Okay.
I guess I should ask the question, well, this vote was on the first vote.
Well, that's why I'm here.
All right, that, after that clarification, the motion, has it been seconded?
Yeah.
Then all those in favor, please say aye. All those opposed, nay?
Nay.
Nay. Thank you. The third item would be the order from Inspector Damon Cody regarding his cease and desist order dated June 25th, 2024. The question really remains is that it's my understanding, or I've seen no evidence that the order has been rescinded or modified since the issuance of the letter. So that is, the question is still valid and enforceable.
Mr. Chairman, through you, my interpretation of that is, I'll yield to our town council here, but if the building inspector did not send that second missing information letter, that basically restarted the clock or reopened the wound or whatever you want to call it. I think whether somebody, but that's what I believe happened. So I would say that letter is, that's my interpretation, that letter from Damon Cody is kind of like null and void, because this was a new letter that was reopening or asking questions. Because evidently the building inspector had some questions of whether that was the actual cease and desist. Otherwise, he wouldn't have sent out a letter.
Would you do that as well? It was requested by them.
No, not entirely. Mr. Costa, could you comment on that?
Sure. So I think that that is one possible perspective. Again, nothing in this case is particularly black and white. So I think one perspective would be that, to use your words, and I'm not sure I could have said it any better, that by virtue of issuing the further letter, the Tom Quinlan's letter of May 31st, the missing information letter, that effectively restarted the clock. That is one perspective. I think that perspective would be supported by the fact that Mr. Quinlan's May 31st letter actually said, if you disagree, you can appeal or appeal to the zoning board of appeals, directing him to do exactly, or directing the applicant to do exactly what the applicant did. Another perspective is the one I heard referenced over here, which is yes, but he only issued that letter because he had apparently received a request for the letter. And so it was really the applicant that was restarting the clock, which, as I explained to you a bit earlier, is not really what should be permissible. There's a third view or perspective, I suppose, on this, and it's what I had said before, which is, okay, it's not necessarily that Mr. Cody's letter has been rendered null and void or has been superseded. You know, that letter indicated that there was a business use of the premises and that business use wasn't permitted and needed to cease and desist. It wasn't appealed. And then a further letter issued that didn't say the exact same thing. It didn't say this is a business use that has to cease and desist because it's in a residential district. This second letter that issued, the one that Tom Quinlan issued, the missing information letter, said a whole bunch of other things. It didn't need site plan review. It said, take a look at this special permit from 2010. It says no business or industrial use in the shed. And so that's what was appealed and is before you tonight. Behind both of those letters, or the defenses or the prosecution of appeal of either of those letters, is the same elephant in the room, which is the agricultural use or not of the site in question. But they're two separate letters saying two slightly different things, and this one was appealed and the other one wasn't. So what weight you give to the non-appeal of the other one is sort of up to you. Even if you were to vote in favor of the proposed motion, I don't think anybody actually moved it, but I heard the statement that it hasn't been rescinded. Is it still valid and enforceable? I mean, even if you vote yay on this motion, where does that leave you? Okay, so we have a valid and enforceable letter from back in 2024, but we have a new letter that says something that has now been appealed and is before you tonight. So, not sure you necessarily have to address the letter from 2024, but if you choose to address it, you can address it in either of the three ways we just discussed.
Okay. Everyone clear on that? That's
Clear as mine.
really, no. Your question?
No, not really. Well, Mr. Chairman, through you, I think if the town is almost acquiesced, or whatever the word is, a fancy word, we wouldn't be here if the town felt that letter had weight, the first letter had weight, because they would have said, time out, this is what we're going to do. We're going to go to land court or whatever. So we're here. So the town of Granby's already made that decision that.
The applicant has the right to seek relief if they want to.
No, we're talking about the May 2024 letter.
That's correct.
What I'm getting at is anybody that thought the 2024 letter was still valid or whatever, and wasn't reset by the second subsequent letter, we wouldn't be here. So that decision has already been made above, beyond
The
us.
purpose of this is not to have something hanging out.
I see what you're doing, Stephen. I agree. That's why I made a statement, is that in my mind, the 2024 letter, people want to argue one way or the other, but that argument is mute because we're here. The new letter, right, if you want to say it's right or wrong or whatever, but the new letter was done, the application was accepted, it went through, we're here. So,
Mr. Chair, can I suggest a motion that I think might be a bit of a variation that might get you where you want to be? So I think and not get you where you want to be in the sense that I'm making the decision for you, because this vote could go either way. But I think that what you could vote to do is, or you could move, you could move to refuse jurisdiction of this case that you just heard on the basis that the 2024 letter controls. And if you vote in favor of that motion, once again, we're done here. Because you're saying the 2024 letter controls, everything that happened after that shouldn't have happened, we shouldn't even be here. And if you vote no, then you're opting to proceed and to consider what we've been hearing over the course of the past 2 months.
Thank you for that clarification, because like I said, I don't want something hanging out there to convolute the whole thing. So I don't remember if the motion was made, so I'll restate it. The chair will entertain a motion to determine that the order issued on 6/25/2024 is still valid and enforceable. Looking for somebody to make that motion.
And I think what I'm suggesting, Mr. Chairman, is that you scrap that motion and start
Yes.
something a little different, right?
Yes.
I think the challenge there is, I don't know that you want to say it is or isn't enforceable, because that's not really before you. I think the question is, do you want to accept jurisdiction of this case, which involves the May 31st, 2025 letter, or do you want to refuse jurisdiction of this case because there's this other letter that you control?
So I think, Mr. Chairman, I think my proposed motion would be that we accept jurisdiction based on the letter from the building inspector, Quinlan, which is what, May 31st, 2025.
All right. Is there a second to that motion? I'm looking for a second. No.
I'll second that.
Just in time.
So this was a motion to accept jurisdiction. So yeah, just to be very clear, a yes vote means we're now going to proceed to what we've been discussing tonight and 5 weeks ago about these other two questions that were presented, not missing information letter, and the agricultural exemption. A yes vote means we're going to proceed. A no vote means we're done, the 2024 letter controlled, you're not proceeding any further on this 2025.
So if we approve and go forward, that indicates the May 31st letter supersedes the one in 2025?
You're not quite making, again, because that's not the question before you, we're trying to find a way where this board doesn't have to make that judgment call, because you don't really need to make that judgment call. What you need to make a judgment call about is whether you're going to accept jurisdiction of this application that's before you.
Is that clarified? Don't know. All right. Well, I'm going to call for a vote that we accept the jurisdiction based on the letter from Inspector Quinlan.
Yes.
And
Well, I already made the motion, and then Robert already seconded, so.
yeah, so yes.
Yes.
May 31st letter, right?
Yes.
Yes.
Yes. Okay, we just asked. Unanimous. Okay. And the final preliminary finding to consider is that the response to additional information requests regarding the revenue analysis is complete. In other words, the question was that it didn't specify dollar amounts, but only percentages. And the question that will resolve that is that we accept that the revenue analysis is complete.
Wouldn't we have done that automatically when we closed the public hearing?
No.
We can't get any more information.
Well, that's not the question. The question is, do we accept the analysis?
Well, Mr. Chairman, I fair point brought up, I make a motion to accept the analysis, because as he said, we would have closed the public hearing if we didn't, so I make a motion to it.
Is there a second? I'll second. Any further discussion? All those in favor, please say aye.
Aye.
Aye. Thank you. All right, now we get to the meat and potatoes of everything. Well, another thing. We are going to turn this into two separate discussions and motions. And that is to determine whether or not to reverse the building inspector's determination that site plan review is required. And the second would be to uphold, either uphold or get rid of the special permit requirements of 2020-10 for the business use and industry. So I think that, council has recommended to us that we approach the second question first regarding the reversing the prior, basically the prior building, the prior zoning board of appeals decision that no building, business use and or industry be conducted, and that by doing so, would automatically determine tasting room is in fact an agricultural use. So let's start discussion on that now.
Well, the special permit in 2010 was approved for a garage storage building exceeding 1,000 square feet with the additional provision that no service or industry is conducted there from or therein.
Right. And your comments?
Storage to me is not an operational facility. In my opinion, I think storage is storage. I'm not getting into the agricultural, but we're going to.
So, Mr. Chairman, through you, and that's the crux of the matter, is when we read, I've done a lot of reading prior, agriculture is the town that voted to, agricultural community. Agriculture is not defined, yes, it's a business, but it's not defined as a business or an industry. So, that's, to me, the question. There's been a lot about the entertainment and all this stuff, and it's just, whether I agree or disagree with that, that really is not before the board. That is a separate license from another board. And our questions is like, our town council said, there's really two questions, is do we consider this an agricultural operation? I think that's our first vote. And then if we consider this an agricultural operation, that nullifies that 2010 letter, because agriculture is not considered a business. Yes, it's a business, you're making money, but it's not considered the pure definition of business, like an auto repair or towing.
Category.
Right. And it's not industry. So that is really, which is kind of my thought, is that's really the simple question. And that's where we have to have a discussion.
Right.
Whether we agree with how and what is going on with the entertainment, or we agree with, a car show there or whatever, that is a lot of background noise or whatever.
Distractions.
I didn't hear one person say, I hated looking at those grapes. I didn't hear one person say, that damn hay baler makes a lot of noise. So the pure facts are, there's a 15-acre parcel, if I heard everything correctly. 11 acres is hay, 2 acres is grapes. So out of 15 acres, 13 acres is farm related. Nothing I've heard that says you have to run I worked at a dairy farm for 8 years. Trust me, it's hard making money on a farm, so many farms are not profitable. So that's, to me, that's kind of like the pure question is, do we consider that agricultural use? Everything else is whether we agree or disagree, that's not our fight. That is the board that issued that entertainment license. And maybe I'm looking at it too simple, that's the way I look at it. Is a 15-acre parcel that has 11 acres of hay, 2 acres of grape, is that agriculture?
Mr. Harron?
I agree. I think it's a lot closer to being agricultural than a auto body business, something like that. You're growing things.
Sure.
Yeah, I agree too. I think the Dover Amendment gives them.
It may not fit everybody's idea of a farm, but
The commercial agriculture is going on there under the Dover Amendment,
Would you like to expand on your comments?
No, I see both sides of it, trust me, I get it, we're in a small farming community. I just don't know where I get caught up is the permit and what it states can and can't be done within the building. But that ties in and it grabs the agriculture end and pulls it in.
Yeah, that's whether you agree or disagree with like I said, there's no ticket sales. But like I said, whether you agree with that, the music there or not, to me, it's that simple of a question. Is that an agricultural use of the property?
Don, do you have any comments, please? No comments.
I have my opinions, but my opinions are my opinions. I don't vote, so I'd rather leave it up to you guys.
No, I would like to hear your opinion, actually.
I think it goes a lot further than what we're looking at. And unfortunately, we as a group, I wasn't here, we weren't here, you weren't here. We didn't drop the ball. The ball was dropped many courts before us. And had it been done accordingly right from the beginning, none of us would be sitting in this room. And with that being said, I don't think that this is the end-all, do-all. It's a Band-Aid, because we have issues that are far greater, but the attorneys capture on them, and we have to move forward as we're being advised.
This is correct, yeah.
And what happened in the past is in the past, and hopefully we learn a lot from it.
Any other discussion regarding that question?
Your thoughts, Steve?
Well, my thoughts are mixed, quite frankly. I have no issue with the operation of the winery on the property, packaging room, things of that nature. My concern is simply the tasting room. And my concern is simply this, is that I don't agree with council's interpretation of it's akin to a farm stand. I disagree.
I think that was a bad analogy, but that's.
And so my other concern is that because looking at it as the alien coming down, as one was mentioned, looking at it, it looks like a bar and a restaurant and things of that nature. Now I get that.
I thought you said you've never been in there, though.
I have.
Okay, I haven't either.
No.
I've never been there.
So my understanding is the state manager, I was looking at the plans and, from the building department, so I do have a concern in terms of how that's being presented. I'm not suggesting that the actions that are occurring within the tasting room are not related to the winery. Evidently they are. And I also further believe that in terms of the revenue numbers, it's difficult, as it was stated earlier through the testimony, that it's going to take some time to build up the number of product that are going to be able to generate almost 2 acres of vineyards. So I understand that this is the basis of it, and I don't think it's equitable to force the owner of this property to say, okay, we're going to measure your standard on day one of your grape output. That, in my view, is not fair.
Mr. Chairman, and that's why I asked the question. I was astounded when I read that 1 acre.
So am I.
Well, it's on the internet, it's gotta be true. But I did a couple of different, and they were all, that's why I said between 6,000 and 8,000. I was getting different answers. One place said 3,950 bottles, another one said 3,120, another one said like 3,220, whatever.
Yeah,
but that's why
I saw Mr. Trumpy nod in terms of the green.
Okay, but that's why I was astounded when I saw that. That's for, 1 acre lot. Yeah.
10 years to get.
But when those numbers be on mature line,
And that's what Steven just said. It's hard, if you leave somebody to that standard, they never get to where they're at. I mean, so anyway. So again, it gets back to what I said, and I don't know if I'd almost be willing to make a motion that, I feel with what we've heard, that 11 acres, okay, 2 acres of grapes on a 15-acre parcel is agricultural. That's an agricultural use. And Mr. Chairman, I'll make a motion
So
to that.
if in fact the board finds that this is an agricultural use property, just speaking out loud for the board, and we move forward, the operation in that building is not storage of farm equipment, if it's retail. And
Well, to answer that question, let me answer it in a specific way. The application that was taken up to change the use was a building permit application under CMR 7-8, which is the building code. And the change of use was to change it from use group S, storage, to A2, assembly. All right? That has nothing to do with zoning whatsoever. All right? Now, the application originally came through as a change of use from S to farm stand. Well, there's no farm stand in the building. And the application was, my understanding, completed with the use of change from S storage to A2. So my comment, and I understand what you're saying, that it's a different use under the zoning bylaws, okay? These zoning bylaws do have a use group S, but it's in a different context whatsoever. It's not to be confused with, well, I shouldn't say that. It is related to building code, but not quite. But we have different use groups in the zoning bylaws than we do in the state building code. So that application was granted because it met the requirements of the building code in terms of analysis was done by the engineers or the architects in terms of means of egress and things of that nature. So that's been all satisfied. But tied to that as well is that there were actually multiple building permits. I'm not entirely sure how many there were, 2 or perhaps even 3, because there were some exterior modifications to that building, including awnings and things of that nature. But again, I haven't seen what has been done. And the question is, and this is tied to the first part of the question in terms of site plan review in our bylaws. So assuming that it's not particularly in Doberman for a moment, that any permit granted for exterior modifications requires a site plan approval. And I think that could be where the building official decided that this whole thing is tied. But I also think that, and I clarified that with my conversation with Attorney Byrne about working with the governing authorities, whether it's the building department or the planning board, to go through a site plan review process to satisfy at least the basic requirements. And I think they were agreeable to do that. Excuse me. But I'm not sure how to answer your question.
I was referring to the 2010 special permit.
Yes, and I know, and that is, the real question is, I understand it, that the conditions that we have in our bylaws regarding building services and industry are in some fashion clearly defined, in other fashions they're not. The building services are only just a few things, and it lists mostly, as I recall, professional services. And that's clearly not what we're dealing with on this. The industry factor is, as some have suggested, is that it may or may not be applicable to this based upon what standard and measure to use. Again, this decision is not easy because it is so, it's muddy. It's quite frankly, it's muddy in terms of what really applies and what doesn't apply here. But the point is simply this, is that if indeed this board does deem that the tasting room is agricultural use, then that kind of ends this whole situation. Is that
Correct me if I'm wrong, but I thought we were determining the use of all that.
Right, so, and I was gonna add on to the motion that was almost made, but not quite. The motion referred to 11 of the 15 acres being hay, 2 of the 15 acres being used as the vineyard, 13 of 15 acres being dedicated to agriculture. I think that was the essence of your statement before your motion.
Correct.
And you said this site is principally used for commercial agriculture. Okay, so that's the site, that's the property, right? Because we're talking about a 15-acre property. But ultimately, what's really before you,
Correct.
you have to address the issue of the site.
When we started, there was 2 questions.
Yeah.
So the first question, is this agricultural? That's question 1.
What's this?
Is the parcel agricultural? That's question 1. Question 2 is whether the tasting room is ancillary to agriculture. That's why it's a separate vote.
That's great. So I suspect
that's why it's a separate motion.
I suspect that you may be getting there because question 2 can actually be 2 things. It can be, is it ancillary, or even before we get to ancillary, is it a part of the agricultural operation?
Well,
right?
I think that's
the second
why
motion.
we have to be correct. We need that. To me, I think and the chairman, I thought, said they're going to do it 2 separate.
And that's fair. And so
Okay.
those are the first 2 motions.
Yes.
First is the site used for the primary purpose of commercial agriculture. Second is the tasting room, either part of that operation or accessory to it. Then to answer your question, if the answer to both of those is yes, well then the question of the 2010 special permit essentially becomes moot, because the 2010 special permit that says you can't use this property for business or industry. If it's agricultural business or agricultural industry, it renders the restrictions in that permit in your bylaw moot because the Dover Amendment supersedes all of that. So that's it. So you do have to answer those first questions those first two questions first. And if the answer is yes and yes, then I think that the next two questions about site plan review and about the 2010 special permit, I think are answered fairly easily. If the answer is yes to those first two questions.
But wouldn't if that was put, if that land was rendered to be in agricultural, make the second question obsolete? Because what they said was that building would automatically fall under.
Well, only if it automatically falls. And I think they're separating the two out because they're first determining whether the site as a whole is used for the primary purpose of commercial agriculture. You could say yes to that question and say yes, but they've got this building that they're using as a nightclub. I know a phrase that has been disfavored, but a nightclub that is in no way connected to the agricultural use that comprises 70% of the parcel. And then the answer to the question two would be no. And then we have more difficult answers to these questions of site plan review and the 2010 special permit. So I think you're correct. Let's address those first two agricultural issues as two votes.
Correct.
And then we can move on to the other two questions.
So, Mr. Chairman, my vote is, my motion is that this parcel is agricultural in nature.
Is there a second to that second? Any further discussion on the parcel? Hearing none. Call for a vote. I'll do a roll call vote on this, please. Mr. Johnson?
Yes.
Mr.
Yes.
Harris? Mr. Sherman?
Yes.
Mr. Richard? Yes. And you can't vote, sorry. And the chair votes yes. So the vote is unanimous by roll call. All right, the second part of that question now, and I'm asking you, Mr. Johnson, to make that motion. Because you're doing such a great job.
Yeah, sure. Well, like I said, I'm repeating myself, but there's just been a lot of noise here about everything that goes on in the parcel. And I did do a lot of reading with the Dover amendment and the definition of, and I forget which council it was, they tried to, the winery is not considered manufacturing underneath the state law, from what I read. You might be able to drag in the beer is so there's a separate distinction there. But with that being said, that is, when you look through everything I read, it's common to have a tasting room with a winery. Now, the question is this an actual tasting room or is it more than a tasting room? I've never been there. So I don't know. I can't say. Is there a menu there where they have food, or is there's food trucks? So it's not in the building.
Yeah. But it's from what I understand, served and they eat it in the building and outside.
Correct. But what I'm saying is there's not a kitchen in there that creates food. So that's, at least I believe so. In place I've never been there. So there's not a kitchen. There's not a menu because it's a food truck. I don't think food trucks, they have food trucks at different park. Right,
There's a menu with wine and prepared food on it, from what I understand.
I'm sorry, what?
There's a menu with wine and probably the beer and prepared food, they're not making it in-house.
So, yeah, so it's they buy the food at a food truck and then the wine. So that's, see, to me, again, I really didn't hear much debate about it seemed to me the debate about the tasting room was more for an end to the means of stopping the entertainment. Everything I heard was entertainment was the problem. And that's not what's before this board. That is a function of the Board of Selectmen that issues that license. So that's not before us, and I do have empathy for everything.
And they put restrictions on that.
But correct, that's what,
You're correct, that's not our.
and so I do, so that's what I said, it's difficult, because everything I hear, I've been involved in town politics and even state for a long time, and this is very, very murky, or I shouldn't say murky, but it just got convoluted because of all the steps. The Dover that we're talking about, that's been around since 1950. But that was only for schools and for nonprofits, I believe, and churches. And then they added agriculture back, I think, 8, 9 years ago or something?
More than that.
More than that? Okay. But so this is still almost like new territory. And unfortunately, a lot of this stuff is above our pay scale, is gonna be decided in courts.
Everything's above our case.
Well, yeah, we're not getting paid. We already established that. We already established that we're not getting paid. But what I'm getting at, a lot of this is just gonna be settled in the courts because it's new. I mean, it's, to me, whether like you said, the ancillary stuff that goes on there is right or wrong, I have to kind of black that out in my head. So, I mean, I think every winery I've ever been to has a tasting room. Every winery, so, yeah. So,
we're refuting that point.
So,
All that matters is, especially back in 2010, clearly stated storage for farm equipment.
but that's where it gets into, is agriculture does not fall underneath that business or industry category. It really doesn't. So that's, so I guess, I'm not quite sure how the motion should be, but my motion would be that, seeing how this is an agricultural use, my motion would be that the 2010 letter does not apply, because it's agriculture.
So, Mr. Chairman, we're not quite at the 2010 permit yet, right? We're still at the first part of that two-part initial question of agricultural use. So I think the next appropriate motion.
So I missed the beat here someplace?
Yeah, the question is whether the use of the tasting room, whatever that.
That's where I'm going with this.
Right. So
Yes.
irrespective of the 2010 permit, whether the use of the tasting room is either part of the principal agricultural use itself.
Yes.
Or is accessory to that use.
Yes.
That's the motion.
Yes.
And it's either yes or no, then we'll address the question.
Yes, so
to make this as clear as possible, I would prefer the motion in a positive way.
So make a motion that the tasting room is ancillary to the agricultural use of the property.
Does that meet your criteria?
By ancillary, you mean accessory, right?
Yes.
Customary and
Accessory, yes.
Yes, it does.
Is there a second to that motion?
I'll second.
I'll second it.
It's already been done. Okay. Any further discussion on that motion?
So being accessory would be needed to assist the farm.
It's part of the agricultural, commercial agricultural, right? It's part of the.
So this goes to that passage I had read from the case law a couple weeks ago, more than a couple weeks ago, 5 weeks ago. So the definition of accessory is customary and incidental. And the courts have said those are sort of two separate tests built into one. Customary is the type of use, and this is my paraphrasing, but the type of use that typically goes along with the principal use. So for example, if this were a single family home, a customary use might be the use of a swimming pool, right? That's a use that is customarily associated with single family homes. Lots of homes have swimming pools. And then is it incidental? And again, a swimming pool would be incidental because you're not spending 90% of your time in the swimming pool. You're using it occasionally. The primary use of the property is the single family residence, and you occasionally use your swimming pool. So swimming pools are typical accessory uses because they're customary and they're incidental to single family homes. So is this tasting room customary and incidental to the agricultural use that's occurring at the site?
And Adam, if I may, did you suggest actually that that could be the second question? You could first just ask if the tasting room itself part of the agricultural.
And that wasn't the motion, so.
I understand.
I think, yeah, so.
I understand. But I think this one's more detailed than.
Yeah, so I didn't jump in because that wasn't the motion, but the question, as I said before, there were two motions you could have made. One is that the use of this tasting room is actually a part of the agricultural use, part of the.
Well, that's what ancillary, in my mind, ancillary is part of the use.
Well, there's a legal distinction.
Okay, that's why
Attorney Jordan is jumping in.
That's why you're here.
I'm sure he wants you to find that it's part of the agricultural use because it probably makes his case easier.
That's the way you framed it.
Yeah, but it is the way I framed it, right. So you can either determine that this tasting room is part of the overall operation. It would be very black and white if you were informed that they were storing wine in the tasting room. They were processing the grapes in the tasting room. That would clearly be part of the overall operation. Now, I'm not saying that what they're doing there is still not part of the operation. I'm just saying it would be very black and white in that case. The suggestion here by Attorney Jordan was that you make that motion instead. The motion you made was that it was accessory. Either way, whether it's part of the overall operation or it's accessory, it still yields the protection of the Dover Amendment. But it is a slightly different question. And I'm sure that, again, from an applicant's perspective, they'd love you to find that it's part of the actual agricultural operation, giving it even greater protection than it being something that is not particularly related, but related enough that it's accessory. So you can decide if you want to amend your
How would you
motion.
do a tasting range of grapes? I would consider that being accessory.
Yeah, I think I feel comfortable with the accessory for the motion.
For additional comment on that, or discussion on that, I asked specifically the question, you may remember whether or not there's any manufacturing or creation process happening in the tasting room, and the answer was no. So it's not used for production. Are you satisfied with the answer? Do you have any comments on it? No. Okay. All right, then the motion's been made and seconded. All those in favor?
Yeah, is there a second?
I thought.
Point of order?
I think it's a second.
You
Yeah,
did
I
second.
Which one?
Well, you didn't second the revised version.
Revised.
I'll second.
Revised motion, okay. Again, roll call vote?
Yes, yes.
Yes. Yes. Yes. Unanimous. Is there a second part of this that we need to do?
Well, there's actually now what's actually before you, right? So the questions that were before you are the two questions that were raised by the letter. Number one, and I'm just going to read it because again, I don't want to try to paraphrase here. So I'm going to do it in reverse order because I had suggested that before. So the first one is a statement by Mr. Quinlan that he found a special permit issued for the garage storage building exceeding 1,000 square feet, I think he means an area. This was attached to the deed. It stipulates no business or industry. He says he was not able to find any appeal indicating a change to the restrictions. I think the implication there is he's saying this restriction is binding. He doesn't say that, those are my words, but he says he hasn't found anything changing the restriction. Please provide it, and if not, appeal to the ZBA. So I think the question for you is, with this having now been determined to be an agricultural use of the premises and an accessory agricultural use of the tasting room, do you affirm his determination that this 2010 special permit condition is binding? Or are you going to determine that it's not necessary to change the restriction because the agricultural exemption supersedes it? And legally, that would be my recommendation. Again,
The latter is your recommendation as opposed to reform.
My recommendation is having, and again, I'm not here to be fact finder, but where you've now made a legal determination that the property is being used for primary agricultural purpose, and that the use of the tasting room is accessory, I will tell you as a matter of law that the Dover Amendment would supersede any restriction in a 2010 permit that says you can't use this building for business or industry. That's my legal opinion.
Can you give a suggested language for that motion?
I'll make a motion, Mr. Chairman, and I'll let him critique it. I make a motion that due to the fact of the last two votes, the 2010 letter stating business and industry does not apply as this is agricultural use.
And my only tweak would be it's not a letter, it's a special permit.
Oh, I'm sorry, special permit.
Repeat that again, please.
I had a hard enough time going all at once.
No, that was the best.
Due to our past two votes, I make a motion that the 2010 special permit does not apply where it states business or industry, because agriculture is not underneath either one of those.
So would it be the motion as it was automatic?
Because these are the ultimate questions before you, so you have to take a vote on the questions before you, because we need the decision
So
to
we're
say.
revoking the 2010 permit essentially.
Without actually revoking, because that's not the question before you really, it's not your authority, but that's in effect what you're doing, that's correct. You're revoking a restriction of the 2010 special permit, because only with respect to the use being agricultural. You're determining that the agricultural exemption in state statute supersedes anything that the 2010 ZBA was able to do with respect to limiting use of the
Mr.
property.
Chairman, through you, we're not actually revoking that permit, it still applies. If the property is subsequently sold, a business or industry will not be allowed to go into that building.
Well, that's correct.
So we're not revoking the letter, we're just saying that letter does not apply to this use.
Right, so the letter authorized the building.
I just want to make sure, because that's not my intent to.
Special permit.
Right, okay.
The special permit.
Are we clear? Is there a second to the motion?
first time.
Yeah, I think I already seconded it. Yeah.
All right. Again, I want a roll call vote.
Johnson, yes.
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 Yes. Chair, yes. Unanimous. All right.
One more.
One more. So now we have to come back to the site plan review portion of the thing, correct?
Correct. So this one is a bit tricky, and I haven't spoken on this yet, but I will now. So, as the board probably knows, site plan review is a tool that your planning board uses. Most planning boards in Massachusetts use it as a means to provide some oversight on projects, and very often projects that are as of right projects. If you're not sure if you want a particular use in a certain location, you don't place it on site plan review. You place it on a special permit. Special permit gives your board or your planning board the discretion to say no. The rule of thumb with site plan review is the site plan review authority, typically your planning board, doesn't have the discretion to say no. It's not about yes or no. It's about how do we provide some oversight and maybe some tweaks to this project to be sure that it meets our standards. So you look at things like site circulation and lighting, adequacy of parking, and you might, as a site plan review authority, you might require dark sky compliant lighting or a row of arborvitae in a certain location to provide screening, things of that sort through the site plan review process. When we turn to Dover Amendment protected uses like agriculture, education, and religion, generally speaking, you can apply a site plan review, but it's kind of, we refer to it, I'm sure other attorneys do too, as site plan review light, because it's sort of like an even lesser version of the already watered down site plan review. Site plan review is already a sort of a non-discretionary process, but when it's a Dover Amendment protected use, you really can't say no because you determined that state statute exempts the use. But the case law still indicates that you can apply site plan review light to Dover Amendment protected uses. So much so that some communities in the bylaws have started adopting bylaw provisions called site plan review for Dover Amendment protected uses. You don't have anything like that in your bylaw. The determination that's been made here by Mr. Quinlan was that after reviewing the change of use, a site plan review is required from the planning board. So I think that you could go really one of three ways with this in terms of how you act on that determination and the appeal of that determination. You could say, he was wrong, this use does not require any kind of site plan review. You could say, he was right, this use requires full site plan review, which is a little bit contrary to what I just told you. Or you can go the middle ground, which is, yes, it requires site plan review, recognizing that it would be site plan review for a Dover Amendment protected use, kind of that site plan review light that I was referring to. That's kind of the middle ground here that I think is an available option to you. And normally I would be cautious about giving you that middle ground because you sort of have to vote yea or nay when a decision like this is presented to you. But I have heard the applicant through counsel state on the record that they would not be vehemently opposed, my words, not theirs, to some form of site plan review. I'm guessing by that, Peter can nod his head if I'm right, that he's envisioning what I'm talking about, which is sort of this site plan review light for a Dover Amendment protected use that would be administered by the planning board.
So to expand on that, my thought would be to phrase the motion in a positive view again, to ask that the board reverse the building official's determination for site plan review. And the answer I would suggest that the board consider is no. That leaves the question open so that the applicant has to go to site plan review, but it avoids the question of what detail or condition would apply to that. And as I stated in the public portion of the hearing, is that if there are what the applicant may deem as overextension or impossible or whatever the thing that they may disagree with, that's an appealable event as well. Is that a fair?
It is the only clarification I would offer is that appeal is straight to court.
Not to our board.
I think you had mentioned before that it would come back to the ZBA. Maybe it used to be that way in your bylaw. A lot of communities had structured it so that appeals of planning board decisions went to the ZBA. There's been a trend over the past 20 or 25 years away from that, allowing for direct appeal of site plan decisions to the courts. And I checked your bylaw after I heard you say that because I wasn't certain. And your bylaw says that appeals are straight to court under 4817.
But
So
it's still an appealable event.
it is absolutely appealable.
So that.
So your suggested motion would be to
Let me see if I can say it correctly so I don't put Mr. Johnson on the line again. The chair will entertain a motion to overrule the building official determination that site plan review is required. Now think about it, that's impossible.
So we're overruling the decision of the building commission that it's required, in essence saying it's not required.
Well, the motion's going to say to overrule the building official, basically for site plan review.
The layman's terms, which would be, he doesn't even.
No, a positive vote would be he doesn't need it. Negative vote, unless he wouldn't have said yes. Okay.
Thus, putting on the planning board to take care of it in their jurisdiction.
Right. You understand that?
Well, I understand the first part, but there's, I heard, this is like,
Yeah.
so if we null and void the building inspector's letter that no site plan review,
Then there's no site plan.
then there's no site plan review. So, what you're, what's that?
All right, so that would be it.
Yeah.
Why, and as part of the additional discussion, is I would express to the board that I think that they ought to have some type of site plan review. Whatever detail.
So by saying that would make them, voting no would make them.
Make them go to site plan review, yes.
So to add a point of clarification, I think that the chairman is making the motion in the affirmative with the intent of he himself voting no on that motion, and maybe enough members of the board voting no on that motion, so you're not overturning the determination of the building inspector, therefore you're requiring a site plan review. But he's making the motion in the affirmative.
With the planning board to do their.
Right, but we've already heard, Mr. Chairman, we've already heard that if a site plan review is invoked, it's gonna have to be underneath what the Dover amendment is. So why don't we just, there's been enough convoluted on this, what about we just, you know, I propose to make a motion that we site plan review underneath the Dover amendment, and now we're revoking the site plan review of, do two votes, revoke what you said, revoke the letter. Or we do the first vote, then we do the site plan review utilizing the Dover amendment, or the Dover, whatever they call it, which is allowed, I believe. And then we revoke the letter, I guess.
Let me break that down into two things.
Yeah.
First, the request from the applicant is a request to overrule the building official.
Okay.
Okay, so that's why.
Okay, so I get where you, okay, so, yes.
So, and.
Okay, so I make a motion that we overrule the building inspector, the site plan review is needed per the May 31st letter, 2020.
Is there a second to that motion?
Yes, second.
Any further discussion? So, just to be clear, a no vote would help force the applicant to go through site plan review. A yes vote would not have that requirement. Do you understand that?
Yes.
He's got it. All right, so the motion was to overrule the building official.
Correct, saying site plan is not needed.
No, site plan isn't.
No, the letter said site plan was needed.
Correct. So if you overturn him, you're determining that site plan is not needed.
It's not needed. Correct.
Correct. So a yes vote means it's not needed, and a no vote means it is.
Correct. Right, okay. Yes.
All right, any other questions or comments?
The yes is an override.
Yeah.
A yes.
A no keeps it on. Yes.
A no keeps the requirement there.
So is this a major majority?
This is a super majority.
Yes, super majority.
Yes. Roll call vote again.
Richard's no. We're starting this side.
Okay.
Yes.
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 No. We did this correctly because we want to.
I heard yes, no. What was the fifth?
Two
no's.
Yes.
Okay. So it fails 3-2 because it fails to get the supermajority.
All right, so conversely then, Mr. Chairman, can I make a motion that the,
I guess what would be the reason I'm not going through site plan?
no, you haven't heard my motion, you're already arguing against it. I make a motion,
Yes.
Mr. Chairman, my motion would be to, part of our order site plan review is needed, utilizing the Dover.
Which we have anyways.
But again, we've done a lot of stuff to reinforce what should happen and what could have happened. And there's been a lot of missteps, and I think we just need to make it clear what our intent was.
So my question to you is, what makes you, there's no specific requirement in the Dover Amendment for site plan review,
Okay.
other than saying, no.
So our vote was a waste because underneath the Dover, the letter is null and void anyway.
Not exactly, because we have two portions of the letter. That's why we have two questions.
So,
All right, before we go any further, I just want to make sure that we are entirely in agreement in terms of what's going on. Go ahead.
Ma'am, so the motion that was just made was to overturn the building inspector's determination that site plan review is required.
Correct.
That motion failed, meaning that the building inspector's determination stands. So his statement was, after reviewing the permit application, site plan review by the planning board is still required. So that's where we stand after the motion has just been made. I think that your job is done because you've made your motions. And so you've affirmed that determination. So now the applicant has two options. I mean, certainly the neighbors have options too. This is an appealable event. But the applicant has two options. The applicant can appeal your determination and try and persuade a court that it's not required to go through site plan review. Or the applicant can make an application for site plan review. And that application would not be administered by your board, it would be administered by the planning board. And to the extent the planning board seeks my consult, then I will provide the planning board with similar advice that I provided you in saying that with respect to their administration of the site plan review process, they have to do so mindful that the underlying use is a Dover Amendment protected use, and it has to be something that's more like site plan light than more traditional site plan. Non-discretionary process that's going to result in a grant of approval, but maybe with some reasonable regulation as is permitted under the statute.
But it's on their board, not us.
That's on their board, correct?
I think this has been difficult at best, and board consideration. I also appreciate the comments made by all people in the audience. They did a great job. We appreciate what we've done here.
So, Mr. Chairman, you would typically have a 14-day clock from the day of the close of the public hearing to prepare and file a written decision with the town clerk's office. You will recall when we were before you, the applicant before you 5 weeks ago, the applicant granted extension at least through the end of this week. I think it was their Friday. So I guess the question to you, having now voted, you are on the clock. Do you believe that you'll be able to draft, or would you like me to draft the decision?
I'd like to work together on this.
Okay. And so,
I know that you're typing furiously there. I'm trying to keep up with notes.
So my second question is, particularly if we're going to work collaboratively to try to finalize this, 4 days is a quick turnaround to get that done. So I would suggest that you ask the applicant for a 14 days from today extension, which is only an extension of an additional 9 days beyond Friday, to be able to file the decision with the town clerk's office. Is that okay?
All right, so I presume that we'll have to send a letter to council tomorrow to confirm that.
An extension request that he can sign and be filed with the town clerk's office. Correct.
And that's agreeable to...
Yes, tomorrow's Veterans Day.
Oh, yeah.
Oh, okay, that's fine. So,
all the more reason for the extension.
correct.
Is that fine with you?
It is.
Thank you. Thank you, gentlemen.
Thank you.
Mr. Motion, Mr. Chairman, motion to adjourn.
Second?
Thank you. All those in favor?